Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have news for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the cable. Dati mihi Anglican, Maurice Service Latino.
Is that correct?
I didn't ask you to interrupt me.
literally not true.
Oh, for crumb's sake.
Good morning, welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Friday to you. Man. It is Friday for sure. Welcome. I don't yet have the automated system set up, but we're trying to keep it current with the counter on the likes today. Try to track that periodically and update it. Not automated yet because my son's off in Raleigh and he's the programmer. So love the counter though; it's awesome. I also love Mindy FS first in chat today. Thank you very much. Welcome. It's good to have you here. I'm glad you're here. We appreciate you being here early. It was nice of you to be first in chat, but we're going to punish you for it. Everything IP related worldwide is your responsibility. There you go. Yeah, sorry. There's that. You're going to do fine. You've won before. You did great then. I'm sure you're gonna win again. So you are in fact a habitual offender. All right, we have some birthdays. Thank you, Josh, for this. We have some birthdays here. Angela D, Stovetop Sue, Thomas P, and then tomorrow, Emily, Jody, and Megan. So Melissa says, my son is 30 today. Hopefully your son is on the list here. Is that that's Thomas P? Because Melissa P, same last name. I see that. So we'll sing to Thomas today. Happy 30th birthday, Thomas, and everyone else. Let's get the, yes, we did hit 73,000. That was great yesterday. That was wonderful. Super excited. What else was, there was something else. Not sure what it is. It'll come to me. We'll do the birthday thing and get ready for court as we're beginning day 5, the final day in the Tyler Robinson preliminary hearing. This is going to be probably a half day is what they expect. And sadly, we're not going to get the resolution that we'd like with the judge issuing a ruling because he said, I'm going to allow briefings instead of just a closing argument, which we were going to do an hour each today and be done. Instead, we allow briefings, and the briefings are a back and forth filing in the court, which is great because we get to read those as we go along. But 50 pages by the prosecution, 50 pages by the defense, another 18 pages. 35 pages by the prosecution. I think it was 35 by the defense, then 18 pages in rebuttal over 6 weeks. And then on August, I think September, whatever it is, it's in like 6 weeks from now, whatever that day is, then that would be, so September 1st, then we would have another hearing with cameras and everybody there, and then we would argue it for an hour each. And then have a ruling. So that's what we have. But let's get the birthdays sung to so we can begin. We've got wonderful birthdays to sing to here. So everyone, wherever you are, if it's legal and you're able, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. That'll do. Happy birthday to you. Happy birthday to you. Happy birthday, dear Angela D. Stovetop Sue and Thomas P. Happy birthday to you. Stovetop Sue. I struggle with that one. Stovetop Sue. All right. Now we've got Emily, Jody, and Megan, and maybe some more. Happy birthday to you. Happy birthday to you. Happy birthday, dear Evie, Emily, Jody, and Megan. Happy birthday to you. There we go. Whew. Just in time. Just under the radar. We got all the names in. To everyone who celebrated their birthday today, happy birthday. I realize there are a million places you could have been and a billion people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy, that is ours. Hopefully we can turn that joy back to you. Make your day just a little more special. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. Whew. There we go. Oh, man. Maybe next year, Nikola. Is it Nikola Tesla's birthday, too? Or is it some other Nikola, not Tesla? Jeff Sneaker Arena, welcome. Yes, we have pancakes. I had bagels this morning, though. A bagel. I'm not a pig. I'm not going to eat all the bagels. I just had the one. That's my stepdad's birthday today, too, says Psychosaurus Rex. He's absolutely incredible. He's been the biggest blessing to my life since we came into it. Happiest birthday to him. Happy birthday, Psychosaurus Rex, stepdad. Oh, drum solo. Here we go. Lissa P says that Thomas was there. They're all having breakfast together. Happy birthday, Thomas P. and family of Melissa P. and all others who are here within the sound of our voice. Have a happy day. Have a wonderful Thomas Peebles birthday.
Happy birthday. You look good.
You look great. You look fabulous. Wonderful. Where are we? Where are we in this hearing? Oh my goodness, we are almost done. Today is going to be a new day. It's going to be a completely new day, and the reason why is because defense has given up. Oh, you're welcome. You're welcome. Defense has given up, and I don't know why, other than that this was going to be their fight. This was the moment that they lived for, that they were going to have their victory riding in on a white horse, and everyone would clap. It didn't happen. It didn't happen. They lost every battle they fought. The little wins they did get in skirmishes here and there were not really meaningful. And if anything, this was just like a precursor for how trial would go if we go to trial. And they're losing. And this is terrible. I can't remember another case where the evidence was this glaring, was this powerful, was this strong, was this convincing, with a defendant pleading not guilty. There's no circumstantial. There's nothing. It's like confession after confession after confession, and caught on video. It's a lot, and I honestly, I said last night, my odds are 75% he's going to plead guilty. And I base that on a couple things. First of all, he doesn't look like he's enjoying court. And great, we don't hold court for the defendant to be super happy about everything that's happening. That's not our concern. We want them to have a fair trial. But he doesn't look like he's having a good time. Having a good time, but his family is miserable, and his attorneys are miserable. I just don't see them all putting their heads together and saying, what should we do? I've got an idea. These last 5 days that really sucked, I bet we could relive this and stretch it over 8 to 12 weeks and have the same outcome. I don't see it happening. But they also can't avoid it as long as the state has the death penalty on the table, because there has to be a jury that hears the evidence for the death penalty to be the sentence that is recommended. A jury has to recommend it. You can't get it from a judge. A jury has to recommend it. State says we want death penalty. It has to be a jury. That's Utah law. And so even if he pleads guilty and says, I just want to be done with this and take my lumps and give me my sentence, even if he pleads guilty, we will still have a sentencing hearing where he comes in and he stands up and he says, I plead guilty, and then we sit down, state, call your first witness, and we will go through all the evidence the state has gathered that we would have seen in trial to that jury in a sentencing hearing so they can determine if the death penalty is appropriate, if that extenuating circumstance, that aggravating factors were met to say, yes, this is an extreme case, death penalty is an appropriate sentence. So there's no way out of it. They literally, their hands are tied. It's the state is the only one that could end this, peacefully for them without dragging them through court, and the state doesn't have any desire to do that. So they're crushed. Let's see. People often forget or don't realize that even DNA is circumstantial, so evidence being circumstantial is not inherently less meaningful. The circumstances of the DNA are quite convincing, though. This is not... It's not a speculation, It's like where there's a chance it could be him and a chance it couldn't. The only thing that there was a chance of in this case is there's a chance that the gun they found where they saw him running, the suspect running to, with an object under their arm, when they found an object that matched what it looked like in the video, there's a chance that gun did fire the bullet. And I guess if you look at it from the other angle, there's a chance it didn't. But we can't say it did for sure because the bullet was so mangled. That's the only reason why. There are a lot of things that point to it. It could be, for instance, the match. It's a 30 caliber class bullet casing. We found other bullets. There was a casing in the. We found the spent cartridge. We found the unspent cartridges. We found the extra bullets back at the apartment. We found the engraver. We've got so much here that without even DNA on the bullets, I think this is a done deal, and I do think he's going to plead guilty because I don't think he wants to drag his family and himself through this, but he can't make it shorter. He can't. Even if he pleads guilty, I think it's the same length of time trial. So maybe he'll just say there's a chance that somebody's going to screw up. Maybe the state will screw up somewhere along the line, and that death penalty will be taken off. That's his best bet. All right. Tanner Horner was like that, penalty phase trial. Yeah, pled guilty and just had a penalty phase trial. We've seen a couple of those. Let's see. We should do a poll if we think he's going to plead guilty. Okay, we could do that. Debbie, let me get everything ready. Let's see. It's 10:48 here, so we've got about 12 minutes before court starts. So if you'll give me just a couple minutes to sort of pay attention to what's happening on the live stream, we'll get Top Mark Media going with the audio settings and everything the way they need to be. Hopefully it saved them. It did not. Great. Let's crank this one up just a tiny bit. There we go. I'll try to keep this updated as well. So. Sure why it didn't go. Maybe we'll go in a second. There it went. All right. Our counter. Oh, I got rid of our counter. I need to bring that back. We were up to 80 some odd objections on this trial. Don't need StreamYard today. Well, it's a goner, so I don't know where it went. Bring it back. There it is. There's our tally counter. 87 is what I'm showing now. So that was our number. of objections. Only about 4 or 5 yesterday, and most of those came from prosecution, not the defense, which was not what I was expecting. A big change from previously. Right. Can he plead guilty just to go to the sentencing phase? Yes. He might have a better chance of avoiding death penalty if he owns up to it to show remorse. Yes. Here's what I think the moves that are still in his court or his attorney can make that could benefit him. I think number one, and the strongest one, would be probably pleading guilty with an allocution, where he comes out and he says, full on, not like I'm saving this for appeal, I'm guilty, but I want to appeal because I don't think this was fair. Where he comes out and he says, I did this. I see myself as a terrible person now. I can't believe I got to this point and took this action. It's caused nothing but pain for the victim's family, for myself, my family. I regret doing this. I wish I could take it back. That's what we would need to see to help the jury. But even then, I think the jury is going to make a rule based on the law. And there are aggravating factors here. That would help. But the other thing that would help is if the jury was possibly not a Utah County jury, and if they got a change of venue to Salt Lake County. That would be, I believe, more beneficial, because the population is very different from a political standpoint. And as much as I hate that there's political aspects in this case, there's issues here. That's one of the aggravating factors, is that the state says that that the victim was selected because of political viewpoints. So that would benefit them. So a change of venue would help, and change of venue would be easier to accomplish if they had a difficult time finding a jury in this venue. And so when they argue, this should not be shown to the public, this should not be shown to the public, showing it to the public would make it hard to find a jury. So not sure if they're genuine in this. So, somebody's racing a motorcycle outside. All right. Let's see. Still no live stream. We'll have that in just a moment. But the court camera, KSL is our pool photographer this week. They've done a great job. All right, Shannon O'Neill, thank you for the super chat. If there's a sticker or question that went along with that, let me know. Bite me. I haven't taken your billboard picture yet. No place I'd rather be. Buttercup sends hugs and butter sugars. You are the greatest, Scott and Mods. Thank you for giving us a criminal education. Thank you for being here. It wouldn't be the same without you here, Rebecca. I appreciate that. Yeah, we do appreciate English in the chat. That's the language most of us speak. So if we can do that, that would be fantastic. There's some other language, channels that will give commentary in other languages, but this one is English. That's because all I know. My kids are learning Spanish, but yes, we get a yes sir from Tumwater Troy. See, Google translates it for me, so it's easy for me to understand. All right. Shannon O'Neill says, here's a question. What was your professional background? Do you have experience in the criminal justice system? You seem very knowledgeable. My background, employment-wise, is in IT, information technology, with the Department of Defense. So I had a top secret SCI clearance and ran some amazing software that tracked servers that were doing really important stuff for the government. And I loved that. That was a lot of fun. But before that, I've got a major. My bachelor's degree is in not criminal justice. I started in criminal justice when I went to school. Switched my major to communications, electronic media. Started working in the news media. Worked at some of the stations that were featured here. I've had video of mine played on KSL. I worked for Fox 13 in Salt Lake City. And I've done a lot of video production for police and been involved in Citizens Academy for Police, campaigns for sheriffs. I just loved doing ride-alongs with the police and everything. I've studied the law since I was in junior high. That's a hobby of mine. I mean, when other kids would sneak out and go play video games at their friend's house, I was sneaking out and going down and watching court. So I've I've read the laws and studied the laws for a long, long time, but I've never had I'm not a lawyer. I've not taken the bar, and it's just been a hobby of mine. I just love to learn from people who know a lot about the law and learn from watching court. So we've been watching court here together for almost 4 years now, and that's just a hobby of mine.
You wear multiple hats, sir.
Selena K says, because I made it home safe and I'm watching from my recliner this morning, not a cell. Yes. Selena, we shared on the podcast, Selena, after honking her horn at the courthouse with everybody, all the bailiffs and sheriffs and everything outside, she then drove over a cone, and the police just about did a roadside sobriety test on her, which she would have passed, but for the knee, right? But for the knee. Anyway, so I'm glad you didn't end up in a cell, our court watcher, yesterday. Let's see. I thought of you the other day. There was a mosquito van parked down the street that I've never seen before. He looked lost. It was probably a undercover van. Those mosquito vans, nobody looks twice at them. It's a great undercover van. Chris Weisler says, good morning, everyone. I'm back enjoying the court case. RA, you're making this my recovery from cancer surgery more enjoyable, and your channel gives me something to look forward to. Chris, enjoy the recovery. Hopefully it's quick and painless, and you're back on your feet and back to doing the things you love right away. But thank you for being here very much, and thanks for making that part of your day. We appreciate that very, very much. Do you have a CV? I do. It's not expert level. I'll tell you that. When you're in communications, electronic media specifically, my what's the professor that's your, like, you've got the one professor that's your go-to person for your whole. Anyway, that lady, she said the thing about communications, you need to know a little about a lot of things. So an inch deep but a mile wide has to be your knowledge base, and that's pretty much where I'm at. Scroll up. I'm up at the top right now. This is the highest I can see. My scrolling up and down is not working very well. Okay, that's not a scroll up. That's change tabs. If I missed a membership message, that's over here. Bite me, Rebecca. I missed this. 42 months makes you an OG. Thank you very much. I read that, but I didn't do the OG. Mindy FS, also an OG. 32 months. What an awesome opportunity this is. Thanks, RA. Britta Aller gifted a membership this morning. Thank you. Gailey May did the same. Shannon O'Neill, thank you for your super chat and the question about the background. Mindy FS 777, our internet owner for the day. It's an awesome opportunity. You're doing great. And now I got the hiccups. And Selena K, thank you very much for your super chat and for your help in watching court for us in person. Appreciate that. We were just a moment away from court starting, watching for a feed. I'll record that. We'll start recording this. Turn on Top Mark Media. Oh, wow. That's funny. Watch a little behind the scenes of how the connections are being made. So that's fun. I think that's it. I think we're in the defense case, by the way. We only have one witness left. What is the analog number thing? The analog number thing is a counter. Right. It soon, very soon, will be showing an automated version of the likes. So as somebody clicks the like button, it would then update to the next number. Right now, I'm doing it manually because my son hasn't finished programming it. But it's a like counter is what it is. But soon you'll be able to click the like button and within just 5 seconds or so be able to see it be accounted for. Also, one of the problems is once we reach over 1,000 likes, you guys can't see how many there are, and this would give you the actual number. A lot of people like to see how many likes were on each live stream, and so this would make it possible. All right, you guys are keeping it busy. Oh my goodness. All right. Still no feed from court. It is 11 a.m. straight up. No camera in the courtroom yet. I'm a little bit concerned, but not really, because each day has been a late start the last 2 to 3 days. Some as much as an hour. I just like the stream, so now the counter needs to change. That's basically... I'm not sure if I'm going to do it automatically so that it updates every time someone clicks like, because I have to use what's called an API, a call in an API where I ask YouTube to send me a number, and it's like a program type communication, not really like a website, and I'm only allowed to do that 10,000 times a day, and that seems like a lot, but it's really not when you're checking constantly to see if something updated. So I'll see if we set it up like that, or if we have it set up so that it uses a command like an exclamation point, addicts, like this one right here, shows an approximate count as well. All right. Nate Eaton said the last witness is an FBI guy or ATF guy. I think both of them. Both witnesses for the state are ATF people, for sure. I might also need to move this so it's not quite so loud. Like if I lifted it up. Well, that's not any better. Figure out how to make it a little bit quieter. Christina, thanks for the silent sand sand castle. No silent in there at all. Thank you very much for that. Appreciate that. Super impressed. Aria's son can do API calls. I can do them, but my JSON programming is not the best. And he just, for his internship, he just designed an application for a fitness company, a new fitness company. He built the app. He's never built an app before. They just said, "Well, need you build an app?" He's like, "Sure, I can do that," because he can figure out just about anything. He built the app, designed the interface, did all of it: the front end, the back end, the database side, the security side, and it's a live app. It's publishing this week, and they're going live with it with customers, and they've done all their testing, and he did it for an internship. He's like, "Oh, easy. That was fun. Yeah, I can do that." And he does it in his head while he's typing it while he's talking to somebody else. That's how he writes code. So he got that from his mom, not from his dad. But yeah, he's extremely gifted when it comes to programming. He loves it. He's very talented. Is it vibe coded? It uses JSON. JSON. Right now I'm manually updating it. I'm pushing a number to it. Once we get the program in place, it's going to be... I could give you the link, but here's the problem. If I give you guys the code to update this, then anyone with the slightest amount of understanding what that link meant could any time change my counter to anything they wanted from anywhere in the world.
Don't put a diplomatic plate on a hoopty.
Yeah, it's not extremely secure as far as that goes, so I can't ever reveal like the code, the key for this, and the identifier for it, or else it becomes someone else's counter at that point. And then no, it's not AI code. He writes it himself. How long is this trial supposed to last? Miss Mary, this is our last day of this trial, if we can get it. I don't know where KSL is.
I saw.
Let me see if we got updates from
I saw a chicken fight.
anybody. Court.
I'm going to sustain my own objection.
I was kicked back, taking it easy.
Let's see.
Happy birthday. You look good.
I'm trying to figure out why we're delayed here, and it just doesn't make sense. The court should be open, so unless they've had an issue at the courthouse that's delayed access. Are there new motions? I can pull those up. Let's take a look at the
Scratch all that. Oh, that was terrible.
at the exchange. Okay, close that. White Hat Hacker, yeah, good stuff. When they were teaching ethical hacking at
I think I'm about to catch a whooping.
at DISA, Defense Information Systems Agency where I worked. They would the first day of class, you'd come in and they had just lock picks and locks all over the room, and it's like, go to town, learn how to lock pick, and so everyone was sitting there just picking locks, door locks and master locks and key locks, and it's important to understand how a lock works, to understand the bypass idea, how to get around it. And it's one thing to try to replicate the key in the lock by using picks and things like that to push the pins the right height and rotate the cylinder and free the latch and open the door. And it's something else to say, or you could just tap out on the side with a hammer and that will work. And as we say in the world of lockpicking, open is open.
Hello.
Grab S6040's message above. My name is Sean. I believe I was your 9th subscriber and watch you every week. Congratulations on 73,000 subs. Keep up the good content coming. Thank you. Thank you very much, 6040. Appreciate that. Welcome. That would make you an OG. Appreciate it. Thanks for the kind words and welcome. As a lurker, now out from the shadows, we know you exist. You'll never be the same. PMJ, member for 18 months. I miss Mrs. R.A. Tell her hello from us. I do too. No, we stayed up talking. We got up this morning and talked about, she's planning the next school year for the kids. And so we're talking about, which engineering classes to do with our older ones, with some of the programs that provide kits and hardware and robotics with them. And then you do the programming on your own. But did you know the Lockpicking Lawyer in his April 1st videos? I haven't seen his April 1st videos, but I'm a big fan of the Lockpicking Lawyer. I like his video style, and he's very, very good at what he does. I did one video opening a master lock on TikTok, and that did pretty well. All right.
Hello.
Where is Court gone? Oh yeah, I was going to log into the exchange and see what.
I'm not a cat.
I'm not a robot. NP4D. There we go.
You don't put a diplomatic plate on a hoopty.
I want another enchilada stream that Mrs. R.A. reluctantly joined, but it was hilarious.
I don't like podiums, Your Honor.
I did something wrong. What did I type wrong? For November, Bravo Romeo, Papa Charlie.
The bar sucks anyways.
That bar sucks anyways. Like that.
Shame on you, sir.
Okay, case number. There we go. This is Tyler Robinson's search. Cost 20 cents. Do it. There's Mr. Robinson. View the docket. Well, that's pulling up. Looks like we've got to update the counter again. You guys are keeping it hopping.
Somebody just sent me a video of roaches fighting. I don't know who won. The zombie apocalypse may be upon us.
Did you see the lockpicking lawyer's address to the locksmith industry a few years ago? It only filmed his hands. I like the style of how he does his videos, and yes, he has had communications back and forth with the industry as in general, as well as specific companies, which are fun. I love when they send him a challenge lock. Judgy McJudgerson, thanks for the kind words. We love that you're here. Thank you. I liked my enchiladas better than Lori's. We did her recipe and mine were better. I'm going to try one more time, says Birdie Beam. R.A., my daughter's other half came and asked my hub's permission to pop the big question today. Well, I hope he gave the permission, because that... I don't know. If the daughter loves him and he treats her right, I'd say yes. That's my rule. So I have one daughter, and that's where I'm at. I'm not going to be the guy who's like, well, how much are you going to earn coming out of college? That part's figure-outable. And honestly, money can present challenges in a relationship that bring people closer together. So I just, for any future suitor of my daughter, just know that if she loves you and you treat her right, that's the most of the qualifications right there. Still nothing from court. KSL feed is up.
Squirrel.
I'm looking at their feed, and I'm
not going to
looking
argue
at
about semantics.
multiple feeds, but
even a blind squirrel finds a nut every once in a while.
no, they've got a still shot. They don't have a feed. That's their still shot. I can make it look like that, but I mean, we could do this and it would look like the feed's up, but it's not. That's all KSL has as well. I guess we can show that. Does court start today at 9 a.m. or 10 a.m.? It starts at 9 a.m. Mountain Time, but that was 13 minutes ago. The judge overslept. Okay, this I can see happening. I love awkward. I'm not scared of silence. I'm not scared of it. Let's see. All right, just looking at I'm on the Tyler Robinson docket page for the state of Utah right now, just to see if there were any filings last night that are important. I don't see any new motions since the one Erica's attorney filed on the 8th, which was 2 days ago. So I'm not seeing that. In chambers arguing something, possibly, but this also means that the courtroom has not been opened yet for the media to come in, and that seems surprising, because usually the bailiffs and everything will open the court before the judge even gets there. So I'm not sure what's happening there locally. I'm trying to keep an eye on Twitter as well, and I don't see. Let's see. I just don't see any updates that would explain what. Oh, there we go. Now we have a feed. Okay, so a feed is live.
Remember in the beginning when we started 110 years ago?
We'll cut on this one too, and we'll go live over there. The decoder, the encoder, on air. So top mark's up. We're up.
When are we going to break for lunch, Judge?
Yeah, we've got motion. That's good. Grizzly Grandma, courtroom addict, member for 5 months. Not an OG, but so happy to have found our RA family. Thank you very much. Love it. We're going to be getting started here in a minute. It is a late start, 16 minutes just for the camera, so it might just be a couple more minutes before the judge comes in. They might be waiting to allow the public to take their seats as well. Okay, this one needs to be... Camera 2 needs to be camera 7. There we go.
Court is now in session.
Whoa.
Calling case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Grunander, Ryan McBride, Lauren Hunt, David Sturgill for the state, and the county attorney Jeff Gray and Chris Ballard are also here.
Good morning.
Good morning, Your Honor. Kathy Nestor, Richard Novak, Stacy Visser, and Michael Burt here for Mr. Robinson, who's seated in the courtroom.
Good morning.
Good morning.
Thank you.
Mr. Robinson, good morning to you. And for the record, the court also recognizes the presence of victim representative Ms. Erica Kirk. Ms. Kirk, good morning to you as well. First, with respect to courtroom protocol, to maintain security and decorum, any individual that exits the courtroom during proceedings will not be permitted to re-enter until recess. After recess, all counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, the court will address the camera operator and the still photographer. If both of you could please approach the lectern.
He neglected to do that yesterday, at least on camera. Might have done it before the live stream started, but I didn't see it yesterday. It was the AP for still photographer yesterday.
The court's purpose in this dialogue is to ensure clarity regarding the expectations governing today's proceedings. Could you both please state your roles for today's hearing?
My role is to capture pool photography, still photos.
My role is for video in accordance with the court decorum order.
And I apologize. Would you mind putting your names on the record?
Tess Crowley.
Megan Thackeray with KSL.
Thank you. Have you both reviewed the court's standing decorum order?
Yes.
Yes.
Do you understand the requirements set forth in that order as it applies to your activities today?
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
No.
Do you anticipate any difficulty complying with the order?
No.
All right. Thank you both. Before we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of Mr. Robinson and Ms. Kirk.
So Tess is
In
with the
furtherance
Deseret
of
News.
those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone or electronic device in the courtroom may be addressed by the court. For those individuals who have a cell phone, I invite you to join me as I silence my cell phone to ensure that the proceedings today can proceed without distraction. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with this court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or of other visible reactions during the hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, and orderly, and faithful to the rights and dignity of every person involved. All right. My understanding is the parties wish to address an issue before we get started. Is that correct?
We may.
Mr. Novak.
Thank you, Your Honor, and good morning. I passed up to the court after providing copies of it to counsel for the state and counsel for the media, a single piece of paper. Does the court have that?
I do. Thank you, Mr. Novak.
Thank you, Your Honor. So every morning this court has a colloquy with the camera operators about their ability to comply with this court's orders. And they acknowledge that they understand the order and that they can comply with it. And the court asks them if they have any problem with it, and they state to the court that they do not have a problem with it. We also spent many, many, many hours of court time addressing which exhibits will and will not be published through the electronic media. And this exhibit, the court ordered would not be published through the electronic media, and it was. And without belaboring the point, the court can imagine our concern that the media and the state who control this exhibit and the publication of this exhibit in the courtroom, as per the court's orders, failed to comply with this court's orders after all of the effort that we made and the court made to make sure that the court balanced everybody's rights, including the rights that we're concerned about, which are Mr. Robinson's. No doubt the counsel for the media and counsel for the state will say that it was a very, very brief mistake, that it was corrected as soon as they realized the error, but it's done. It's out there, it's photographed. I'm informed secondhand that if I want to buy this image and maybe even have it framed and put behind museum quality glass, I can do so and put it up in my office. Obviously, I'm not going to do that. But my point is, it doesn't matter
Put under the L category,
how long the court's order was violated. When we live in an electronic world, it's done and it's permanent. And we just wanted the record to be clear that we're concerned that the court's orders have been violated, and they've been violated with respect to an order that was specifically designed to protect Mr. Robinson's right to a fair trial. And I don't want to belabor the point any further. I'm also not going to refer to the exhibit with any more specificity because it's not necessary.
Is there a requested remedy or potential sanction that you feel is warranted given the actions which you have outlined this morning?
I think that we would like to think, when I say we, I mean Mr. Robinson's counsel, about that. We have, as the court knows, repeatedly asked this court, moved this court, not to have electronic broadcast of this proceeding, of any of the proceedings, and specifically this proceeding. The court denied those motions and overruled our objections to the specific EMC requests. So I think it's a little premature, but I can represent to the court that we will suggest a remedy in advance of the next hearing.
Well, Mr. Novak, I appreciate that, but I would ask that if it is something that is concerning, that it be addressed immediately. So I'm not going to wait
You
until...
get now. You don't get a freebie for later. Get out of jail free.
I recognize and appreciate what you have described, and this was on my mind a lot last night as well.
Okay.
I don't want to sit on this, so I ask you respectfully to confer with your counsel and come up with that, because I want to address it. I agree. It is concerning, and it warrants examination and to be addressed immediately, especially as we have a little bit left of our preliminary hearing. So I want to give it the weight it is needed, and I don't disagree with you.
Then why don't we beg the court's indulgence? We don't need to empty the courtroom. We can go talk about what we think an appropriate measured sanction would be, and we can bring that suggestion back to the court in a few minutes.
All right. Well, before we do that, I want to turn to the state and to the media to address what you've addressed, and then obviously if there's a part two, then therefore...
And I appreciate the invitation, and I also appreciate the court's desire to address the consequences, if any, immediately.
Thank you, Mr.
I was not trying to delay it. I just think it's an issue which warrants some thought. The court has said it gave it some thought. We will have a suggestion very briefly.
Thank you.
It was so brief. I was looking down when it happened. I didn't see it on the screen. That's how brief it was. Somebody sent me a screenshot of me looking down and missing it. But
thank you, Your Honor. I think at the outset it's important to recognize that everyone's doing their best here. The court is, I know the clerks are, I think the media is, we certainly are, and the defense is. This issue came up in the context of an examination of a witness. One exhibit was published. Before the exhibit at issue was also brought onto the screen, I explained what we were going to do, and then the exhibit was brought onto the screen. I reviewed the video last night. The camera captured this for approximately 2 seconds. The camera operator, I think acting in diligence and appropriateness, immediately panned as soon as she realized that there was a new exhibit on the screen. The court took it down. As soon as they realized that an exhibit was on the screen, I immediately instructed my paralegal to take it down, and it was. Defense, I think everyone involved here made quick and appropriate efforts as soon as they realized a mistake had been made to remedy and mitigate that issue. As I explained what I was what we were going to do, defense counsel did not object as that happened. And the reason I bring that up is because of the requirement for timely objections. Moreover, I do want to say this exhibit was read into the record. It was allowed to be read into the record earlier. It is also in an earlier pleading, which is the information. This portion of that exhibit, I understand, is in the information. And it is largely cumulative of Exhibit 16 and 16.1, which were previously admitted into evidence and published to the media. Finally, we are going to be dealing with a lot of publicity when it comes to media coverage, and I think that's really where the remedy is going to be addressed. I understand there may be a remedy that can be fashioned today to prevent this kind of thing going forward or going on in the future in this hearing, but I think ultimately that's where this will be addressed. Any other questions from me, Your Honor?
Well, not at this time. I will afford you the opportunity, obviously, to respond when the defense comes back. I want to weigh this and taking in consideration, and I find your representations to be accurate as to what occurred. I believe that I noticed it and asked for it to be taken down because I have a live stream on my screen for that very purpose. And the sequence, I believe I made note, and if I'm wrong, please correct me. It's been a long 4 past days, but that's the only addition that I find to the representation. And certainly, Mr. Novak, feel free to correct it if you believe the sequence was any different. I just want to make sure a clear record is being made of what happened in order for whatever happens next to be appropriate and proportional to the actions that occurred.
No, and that's consistent with my memory, and I also reviewed the video, the live stream as well, in preparation for this issue today. So that's exactly what I think happened. From my perspective, examining the witness, I did not have a view of what was being published to the public and the media. And so I think the court immediately, as soon as it recognized that, brought that to everyone's attention.
Thank you, Mr. McBride. To the media.
You're asking the photographer to know by exhibit number what they can film and what they can't.
Good morning, Your Honor.
Good morning.
That's a lot.
Appreciate the opportunity to be here to speak on behalf of the media. I think our understanding of what happened is consistent with what both the defense and the state have said here. So I don't want to belabor that point. But here's how I understand them. There's two exhibits at issue. Those exhibits were used yesterday in part because the juxtaposition of those two exhibits might have provided some sort of benefit to the court. The first of those exhibits was asked to be published through all three of the court's phases. The court said it will be admitted into evidence, be shown in the courtroom, will not be shown on the cameras. That happened about 3 hours into the hearing. That all went smoothly and well. That operated exactly as it is intended to. That requires the participation of everyone, the court, the defense, the state, media, camera operator, all to do that well. Later in the day, when in the video I reviewed, this was about 5 hours into the run time yesterday. The second exhibit that was going to be compared side by side was introduced. That also went through that three-step process. In that case, the court said that that could be admitted into evidence, shown to the court, and then also shown on the cameras. So it was put on the courtroom cameras. At that point, there was what I think is a useful practice by the camera operator to wait a beat, because sometimes mistakes do happen, right? In that case, though, that was authorized. So the camera then panned to the screen, which is set up specifically for the camera operator to be able to capture that. Examination on that exhibit began. Then, because the examination seemed to call for that juxtaposition, without much warning for anyone involved, the previous exhibit that was intended to be juxtaposed was placed on the screen. From, I think, a observer's view who didn't know where the testimony was going without warning. The camera operator, I think quite astutely, within seconds, recognized this is a different exhibit. And recalling the court's prior order, recognized I should pan off, and did within seconds. I think at the time that was happening, the court also caught that and said, let's not do that. Now, and that was the end of it. I think the 2 seconds is about right. I don't want to minimize that. I understand the point that Mr. Novak is making. We are operating in some ways on high wire. And we are trying to place as many nets as we can, and all the parties are working together to try to do that. But in the age in which we live, one of the challenges is that sometimes when something like that is placed on a live screen, someone can screenshot it, and like Mr. Novak said, if they want to put that for sale on the internet, then they can. That's why working together to ensure that even small mistakes like that don't happen is critical. And the media has the media coalition that are given the opportunity and the benefit of being able to be here to run cameras and to take photographs have complete buy-in on that point. There are, of course, people out there watching a live stream that are not part of our coalition that we can't control, and that's why it's so important that we get these pieces right. I do want, without going too far into the evidence, to note not only that several lines of this exhibit are available publicly in the information, but that the full text, every word, of that exhibit is contained in a search warrant, in this case, that was initially filed on September 17th. This is in the 4th District, but in a different court. Was held for 6 months, as search warrants often are, but then on March 16th, March 17th, was released in full. On page 7 of that search warrant is the full text of this exhibit. I don't want to suggest that anybody gets the right to say, well, I think it's public. The court has said don't show it in the screen, but since I think it is, we'll just come back later on and tell the court it's not a big deal because it's already public. That's not how it works. If we say we think it's in the public, the court says, I understand that, but I'm going to make an order. That order should be adhered to. But I do, for the purposes of prejudice, for potential remedy, for the court's concern and the court's sleepless nights, I do want the court to know that as well. And members of our coalition have pointed out to me as we've talked about this, while we take this very seriously, it is true in this case that the full text of that, not the image of the exhibit itself, but the full text is already in the public sphere, has been reported on, and is out there. I only want to reinforce, to close, the recognition that the media, our coalition, I, as an attorney for that coalition, have an obligation to make sure that mistakes don't get made. And in this case, even though I believe that the camera operator didn't act in violation of the court's decorum order, didn't do something that was forbidden by that there was an order that said, don't publish this exhibit. And because it flashed on the screen when the camera operator was filming that screen, that did happen. The media is fully bought in. I, as one of the attorneys and the other attorneys for the media coalition, are fully bought in on a goal to make sure that this kind of thing doesn't happen. Of course, I understand Mr. Novak and the defense's need to make a record and make an objection. And I also recognize and appreciate and understand the court's role in trying to make sure it imposes whatever sort of direction, caution, sanction, response that it believes is needed to make sure that its orders are recognized and adhered to. And I want the court to know that we will understand that and will comply with whatever it is that the court orders.
Thank you. Anything further before we break? Mr. Novak?
We don't need a break.
Okay.
They figured it out.
Well,
The court wants a break.
I want to review this. I'm sure there is a stream out there. I want to look at it again in order to appreciate the full effect and exposure. I remember it, but given the nature of this and trying to weigh the constitutional rights of all parties, I want to be thorough and look at it exactly. So as we move forward, as I evaluate what's being requested by the parties, that I am at the level of knowledge, and because what it is, it was on screen. I want to look at it, how long, what exactly was on screen, and in order to be at the point of saying, okay, I fully understand. I mean, I was here, I saw it, I noticed it on the screen, but again, I want to take that extra 2 minutes to review that.
I'm not suggesting that we rush through this at all. I just wanted the court to understand that our request for the remedy and the sanction, we are prepared to share that with the court, but we can certainly wait until the court has had an opportunity to review whatever the court thinks it needs to review. The permanence of this violation of the court order is a different issue from how long it took to correct the violation. It's a permanent consequence. In other words, that image is out there forever and ever in violation of the court's order, no matter what actions the court, the state, and the media took to remedy it, because that's the technological world we live in. So that's my response, if I may, to the arguments. But we can hold our suggestion until the court's ready for it.
All right. If the parties feel it'd be helpful to confer while the court is reviewing it, you may, just so that if you choose to, I encourage it. If you don't, I respect that. A court's going to take about 5 minutes. Again, I just want to review it, to be brought up to full speed and just to have it freshly in my mind.
I'm going to make one more point, if I may, and that is this is not the first time that this has happened. We had earlier proceedings in this case where the cameras depicted images inside the courtroom that the court had prohibited, and the court imposed certain consequences on the media as a result of that. And so that's just something to keep in mind, in my opinion, if I may. Thank you.
All right, before the court takes a 5-minute recess and to review this, does any party need the benefit of the record based off the dialogue between me and Mr. Novak? All right, not seeing any party respond. The court's in recess. We'll come back at 9:45. Court is in a brief recess.
6 minutes. Judge, while you're going, if I could suggest, we have a great live stream you can check out. It's respectful. It's all good. No problems whatsoever. Oh, yeah. So, yeah, that happened. I missed it. I missed the note being on the screen. It was so quick. I was looking down, and thank you to whoever sent me the update. Let me update the counter for you. On the likes, we're up to 842. Keeps going up. Keeps going up. But as we wait for the judge to make this decision, I really think the impact of the defense basically wants to say it's not that this is new information that's out there that's the problem. It's that they violated the order. Judge, I'm offended for you, right? Hang on one second. Let me see who this is. Hang on one second. Trying to find. Hey, Joe. This is R.A. How are you doing?
Yes, I'm watching your proceedings, and I didn't even see the note.
Yeah, it was 2 seconds. It was so quick. I was looking down, and what happened was there was another exhibit on the screen, on the TV, that the camera was allowed to film, and then the prosecution, in using this with questioning a witness, went back to the other one. And the cameraman's like, pan, and so the defense is yelling foul, but it's really, if anything, it's on the state, it's on the court. Look how many times yesterday you had defense lawyers or somebody, the state saying, so no, just to be clear, so this is going to be admitted, not shown in the courtroom, or is it going to be shown in the courtroom and not on the, even after the judge made the ruling, they're going back saying, can you please keep this straight? Because you've created a monster mentally to try to follow. And by doing this by number in the head of the cameraman, it's like, oh, wait, okay, now they're calling for exhibit 14.2. That was a yes show. Oh, no, that was a no show. Yes, it's terrible. Yeah, it was quick. But, Joe, go ahead.
And then just one, I know you have to get going. You did hear about the Cora Richardson case, right?
The appeal?
Yeah, the appeal that the judge that oversaw that is not going to take it over. I know you have to let you go because it's getting back into court.
No, it's cool. We've got just a minute. Judge Mrazek, in that case, he is having another judge decide if it should be recused. I think that's my understanding. I thought initially that it was a recusal. But basically, Corey Richards is crying foul, saying I should get a new trial because the judge was unfair, and he was so nice to the prosecution, and he hated us, and I didn't see that. Judge Mrazek is a model judge in so many ways. But
if there is a retrial, do you think that Miss Nestor will be the attorney for her again?
I think so. I don't see why she would be off that case if for a retrial. I think that she knows it very well. She's a public defender. I would say, I don't know why you would switch. She's a great attorney. I mean, anybody else step down, okay, for defense.
So she is a public defender?
I believe. Well, she's not a public defender. She's assigned by the state and paid by the state. So she's a big name lawyer. But because there was conflicts in the public defender's office, the court appointed her, and so is paying her to be. So it's in a sense it's a public defender because the taxpayers foot in the bill, but she's not in the public defender's office.
Okay, and just one last one. I know the judge from this trial. He looks very tired.
He looks much more tired right now than he did at the beginning of the week. This has probably been more difficult than he anticipated. I don't think it's more difficult than he can handle. But this is one that, working a full docket and this, he's going to need some time off after this one. It's a great point, Joe.
And so he will not rule today on the bind over, will he?
Unfortunately, no. He might not have, even if we heard the closing arguments. Even if they got up and they each gave their closings and then the judge said thanks, he would have said, I'd take this under advisement. I'll issue a ruling in a week or two. That's typically how we see in some of these big cases. But this way, the defense wants to do the closing basically in a written form, which is, it's easier to make sure your argument's all written out and thoughtful and cited correctly. It also gives you, a lot more leeway, 35 pages for a closing. That's substantial. That's an hour's worth of closing, 2 minutes per page. And so we're going to have the summation, the closing by the state, and then a response by the defense, and then the state gets another 18 pages to respond to what the defense said. And then on September 1st, we're going to have a hearing before the judge where everyone's back in person where they probably don't read verbatim all their documents, but to give the condensed version, maybe a 20-minute each side, and then possibly the judge would be able to rule, or wait another week and make a ruling then. But yeah, the bind over is not going to happen for a while. It's going to be the end of the early fall before that happens.
So what do you think in your what do you think is going to happen to the media with this? You think that the media will be sanctioned for violating the judge's rules?
I think the judge is going to look back on this and see how it actually played out. And I think the media's representation of what happened, the media lawyer, was very accurate. And as he sees that, with that in mind, saying we were showing what we were allowed to do, we followed the rules when this was admitted, and then the screen switched, and we're like, oh, crap, we had no warning. And so faulting someone because the state decided to show something that the media shouldn't see on the camera, on the screen that the media is allowed to film. I think any remedy would be minuscule at best. Although he does have reason for concern going forward. I know he wants to keep this open. He's said that many times. The right to media is broad.
And maybe what they should do, I know in the future, for future Zoom, they should say to the state and to the defense, to the media, now this is going to be shown on the screen. Can you please move your camera?
Yeah. Speaking of moving the camera, right now on the feed, we're getting an extreme close-up of somebody's hair, and the camera is auto-focusing on it. We can see like split ends and clumps of gel, and wow.
But I just wanted to say I've been watching your channel for a long time.
Yeah. Well, thank you, Joe. I appreciate that, and thanks for the call, for the thoughtful questions. You've got a great voice too. You should do something like this.
All right, thank you. I know you have to get back to court.
All right, thanks, Joe. Appreciate it. We'll see you.
Bye.
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 Joe had great call quality, everything. That was good. So this portion of the trial is brought to you by Head & Shoulders, the anti-dandruff shampoo. That was an honest mistake. This is why you do not set your camera to autofocus. And I'm sorry, but this is a pet peeve of mine. Autofocus anybody walks in front of your camera and suddenly that is the focal point, and your camera will draw everyone else's eye to it by blurring everything else and putting that in focus. I can see for a lazy camera person, I'm not saying KSL's camera person is lazy. I think she's doing a great job, but it's always best to get a manual focus. Typically that's done by zooming in almost as tight as you can, as far as you can on the subject, finding that solid focus that where it peaks. You can turn on peaking on your screen, like on my screen right here. On my screen up here, I've got a blue peaking signal. You can't see it because it's up a bit. But there's just blue highlights that show up on the camera when it is sharply in focus in that area. So you set that, and then you zoom back out, and as long as you haven't messed up what's called the back focus, then it would remain in focus when you zoom out. So they need to broadcast on a delay. They do it with sports. The problem about a delay is you now need the ability to cut to cut that part out, and it means that however long the delay is, that is how much time you have to catch and correct the mistake. So if we have a profanity delay, that's a 10-second delay. If somebody drops a swear word, I have 10 seconds to get to my machine, hit the button at the right point to cut out that time. And now our buffer is gone. We'll need to break, stop, and start again 10 seconds, and then it'll start showing again. It's difficult it's harder to do than you think. And when we have a live feed like this is a live feed that's transmitted from one camera connected to a live view box sitting there in the courtroom, and it just goes out. And then our live feed for KSL is put out on an unlisted YouTube link. So we all had 5 days of links, one for each day, where we could go to that link and have access to the feed as members of the pool media. And so that's every single person all 135 of us that are part of the pool watching this then has to put in a break and stop and clip and cut out, and it's just not possible. It's really hard. Some courts do say, like Corey Richens had said, Judge Mrazek, we didn't like this, but he said, during pretrial stuff, he said nothing can be broadcast until the end of the day sometimes. So you'd have a hearing, and then at the end of the day, you could stream the hearing. Other times he said it has to be operated with a delay. We never had an instance while the delay was in place where we had to utilize the delay to cut something out that wasn't supposed to be shown. But can someone please give the note time shown from yesterday? Trying to see. Who sent that to me? I'm not seeing it. It must have been sent to me directly. I don't know. I'm not going to show it again, obviously. As a member of the pool media, we try to abide by the judge's rules. Shouldn't you comply with the court order? Yes, you should. But if we're doing something the court has allowed, and then literally as fast as I can cut from here to here, that you're now doing something that's not allowed, and it was not your decision to switch, even if it was 1 frame, and that's 1/30th of a second, even if it was just 1 frame, you can get a crystal clear screenshot from 1 frame, from 1/30th of a second, and it would be out. It would be the same impact with the lasting duration that the defense is worried about as anything else. And so there was no mistake by the camera operator. It was defense, or the state, then went back and showed on the screen, when we're allowed to be showing what's on the screen, something that should not be allowed to be shown on the screen. I wouldn't put this on the camera operator at all. All right. Judge is watching someone's live stream. I'm curious which one he's watching. Sorry, that brings me a lot of joy. I'm normally okay with deleting something out. The only problem is when we go live all day long, like we did yesterday, YouTube doesn't give me the ability to edit out a segment. After 6 hours, I lose the ability to edit out a segment. Yesterday's live stream, I think, was over 6 hours, and so for me to edit that out, I would have to download it off YouTube, pull it into my editor, take that little piece, crop it out, put it back together, and put it back up. So then I would lose all the views. It would take a video that that had, yesterday we had 25,000 watch hours yesterday, and it would take that down, and that would be it would count against me. I'm removing the views, so it's impactful. It was 9 hours. It was long. It was a lot of work. I think defense, if I were them, I would ask for what they asked for all the time. I would say we move that the media be thrown out of, or kept out of hearing, that electronic media coverage be kept out of all the pretrial hearings, which is terrible for us. Absolutely awful. Worst possible scenario. But I would shoot for the moon here if I were them, because how many more shots of this are you going to get? It's not a It's not a deal breaker, right? They can't blame, because this was already put out by the state in, verbatim in the arrest warrant. They can't really say, now all this is out there. Look, it's all because of the media. Nope. We already knew that there was a letter written by Tyler Robinson to Lance, and exactly what it said, word for word. We already knew that. Don't think the judge will go that far. Asked to throw out that evidence. That's a bit much, and I think it's that would be improper as well, because it's something that was already out. If anything, this is going to impact how the media can record. It's not going to change. Definitely not going to take the death penalty off the table. It's definitely not going to change. It's not going to be a fine. There's no contempt for the cameraman, because I don't think even the judge could find that this was a willful error on their part, or even something that they could have anticipated. Aurora, the judge is watching someone's live stream. I'm not sure who. It could be a clean feed like AP. It could be a clean feed like Law and Crime Court TV. It could be it could be our feed that the judge is now watching from yesterday, trying to find the point where that 2 seconds shown on the screen occurred, and he might not be able to find it. That would be funny. That might take a long time for him to find this. Yeah, the note that we're talking about, if you're reading this, I had the opportunity to take out Charlie Kirk, and I had the opportunity to take out Charlie Kirk, and I took it. It's basically a note that he placed under the keyboard, his keyboard of his computer, and then he set up an automatic text message with a timer on it. So at this time, this text message is going to go to Lance. And it did. It went to Lance, and he's like, what's going on? He read the note under the keyboard, and Tyler's like, oh, I tried to delete that, tried to stop that from going out. He had second thoughts about telling Lance about it. He wanted to keep this a secret till he died. And so now Lance knows about it, and burn this, destroy these text messages. It got a little crazy, but it speaks to, when you're talking about premeditation, this case has it in spades. Tons of that. Judge is phoning a friend. It's all over the tubes of YouTube. It's everywhere. It's all the social medias have screenshots of it. He's going to want the remedy to be no media. Is that the one where he says he regretted what he did? No. This is the one, in this note, he wrote the note before it happened, knowing that there was going to be a text message that went to Lance to explain what he had just done. And so he wrote it sort of like to inform him. And even in the note, it said, I'm not sure if I succeeded or not. I'm not sure if I succeeded or not. When I'm writing this note, I'm not sure if I met my objective. But I'm probably either facing, either I'm dead right now, or I'm facing a very long prison sentence. So it was a lot. I love scheduling some of my text messages. I've never scheduled a text message. I've never had that much forethought when it comes to texting. What if they've caught him without the note on confession? I think they would have. Family recognized him from the video. We knew the car. We had the car. We had the video of him going around campus. I think they would have got him. Why is he fighting this? He knows he did it. He has the right, as everyone does, to a jury trial. to force the state to meet the burden. It might be an easy burden for the state because of the amount of evidence he left, even though he thought he left no evidence. But yeah, is that right? How do you schedule a text message? I feel old. It might be an app. I don't know. Somebody else. I've never done it. Britt Aller says, some of my coworkers thought that TR was framed. After seeing the evidence the past 2 days, I think he did it on his own. He says he did it on his own. He said he planned it himself over 2 weeks. There sure is a ton of evidence that points to him doing it on his own. And I haven't seen any evidence that points to somebody else being there. I mean, the little bits we had, the part where the defense says, the bullet doesn't match the gun, but they couldn't say it is a match because it was so damaged, but it definitely is the right class. It could have been fired by that gun. It's just so damaged we can't match it to any gun. That's just how the damage on the casing went. Then we also have DNA, which is pretty strong. I haven't seen any other evidence that would say that let me just crossed 1,000 that somebody else was involved. The other bullet on the roof, the unspent cartridge on the roof, the .223, that was from a police officer who was, in responding to the situation, got up on the roof looking for a shooter, they were looking for an active shooter somewhere. And at one point, he cleared his weapon when it was loaded and failed to pick up the unspent cartridge. So, slow dissolve there for dramatic effect. Stillvan says, I'm used to hearing a lot more innocent until proven guilty and allegedly from you. Are you fully decided at this point, or do you think your mind might be changed by some evidence? We've seen a lot of evidence, a ton of evidence. And if this were the actual trial and we saw this amount of evidence, as a juror, I would be quite convinced. I'd say beyond reasonable doubt. I purposefully, we did not pull up the letters, the information that we didn't go through that. We just looked at it as the evidence came through in this preliminary hearing. And there's a much lower burden in this preliminary hearing just for a bind over. But this is an open and shut case in my eyes. I have not seen anything. I mean, if there was a good defense out there, if there was somebody else did it out there, there would probably be some evidence to support that, and I have not seen any of it. Instead, we have admissions by the defendant in writing, in text messages, on Discord, and through family members. We have DNA evidence all over the crime scene as far as the gun, the towel. Yes, Lance's DNA is there as well, but they shared an apartment and he used a towel that they both had DNA on. Yuck, but still that would explain why Lance's DNA is on the gun and the towel. There's so much here. We've got the video that matches Tyler Robinson's description. We've got his phone. I'm sure there's going to be some tracking information that's going to come in from the phone. It's just what more do you need to see, right? At some point. Lance clearly wasn't involved in my mind. I think his friends didn't know, didn't even know that Tyler Robinson felt this way. Possibly even Lance says, we didn't talk politics ever. Sometimes he'd say some things about Trump and he wasn't happy with decisions he made. But I had no idea. I never mentioned Charlie Kirk. So I think if you look in the Discord page, that when the friends say, "Hey, Charlie Kirk got shot, he's dead," and the first response from the friend is, "Wow," it was something like, "I didn't didn't like him, but this shouldn't have happened. That's sad. And then you get Tyler Robinson's response. Sorry guys, it was me. I did it. Oh well. Here it is. Thanks for all the laughs. Good times. See ya. Lance came across extremely truthful. It did help that he had an immunity deal as far as immunity use on anything he testified, and that was the second time he had testified.
What more do you need to see?
Ali G, yes, thanks for the soundbite, Jen. Seeing the evidence helps dispel misinformation and conspiracy, and there has been a ton of misinformation and conspiracy on this one. Just an absolute ton. And sadly, some of it has targeted the people who were, in my opinion, victims in this case. And turning that and saying, with zero evidence, okay, instead just using the fact that one of the victims is profiting, right, is talking in public about this and making money or furthering a political agenda or their personal business, using talking about this as the motive. That I see nothing that would support that there was any. Oh, looks like the judge is back.
Court is back in session, noting the presence of counsel in all parties, and where we left off is the court took a recess to review the video, and I appreciate the patience of the parties as well as everyone in attendance when it comes to constitutional matters and balancing constitutional rights and transparency. This court will take the necessary time to make sure it's given the weight it deserves, and it is deserving of every moment that has been spent. Mr. Novak, turning to you. And perhaps before you begin, let me go ahead and make a record of what I noted that is at issue. And after I put this on the record, certainly if either side wishes to be heard about the court's understanding, I welcome your comments. Exhibit 24 was displayed on the monitor visible to the media camera. Exhibit 16 was displayed on all monitors and appeared on the live stream for approximately 3.5 seconds. The camera operator redirected camera before any party called attention to the display of Exhibit 16. Approximately 16 seconds later, the court observed the image and stated, "Let me stop you, Mr. McBride. I'm not sure. Is this being broadcast?" Mr. McBride responded, "Let's take that down." The full text of Exhibit 16 had previously been made public through a search warrant that was publicly available on or before April 2026. The portion displayed on the monitors did not contain the full note and consisted of approximately 78 words. Approximately 15 of those words were included in the information filed on September 16th, 2026. In addition, the full note was read into the record during the preliminary hearing. The court previously ordered that Exhibit 16 be admitted into evidence and permitted its display within the courtroom, but prohibited its publication through the camera used for the live stream. And that concludes the findings of the court as it relates to this issue. Do the parties wish to be heard before we go into what you're requesting about the record on what occurred?
Your Honor, your recitation is accurate. My earlier comments were based on my memory of reviewing this last night. In the recess, I reviewed the feed again, and what you have said today is accurate.
Thank you. Mr. Novak, any?
No, Your Honor, I don't take issue with the court's factual summary.
All right. Turning to you, Mr. Novak.
Thank you, Your Honor. We're going to renew our request to exclude all electronic media coverage from all future proceedings. That was our motion docketed at number 305, and that included video cameras, still photography, and audio. This is the second time that the court's orders concerning the scope of electronic media coverage have been violated. I'm a baseball fan, and I just don't think the court needs to wait for the third strike. 2 strikes is enough. If I may, the alternative remedy, which we think is not wholly adequate, which is why we think it's an alternative and a less desirable alternative, is for this court to both reverse its prior order authorizing electronic media coverage of today's hearing, which we had previously
we might get kicked out
filed
today.
an objection to after the court, I would say preliminarily granted the requests for today. That was sort of the chain of events. And that the court proactively preclude electronic media coverage at the last day of the preliminary hearing, which will be September 1st. Now, I understand that there has not yet been a request for electronic media coverage for September 1st, but there is no doubt that there will be, just as this court previously observed that it wasn't prepared to preclude electronic media coverage at the preliminary hearing because there had not been any requests. There were requests, and those that were timely were all granted. The court denied one request because it was not timely for one particular day. So I guess the way it would be is any request for electronic media coverage of September 1st will be denied because that's the appropriate sanction for what happened yesterday. The fact that the content of the exhibit was previously summarized by the state in certain documents which became public because the state didn't take any actions to seal them beyond the 6-month period. The fact that the contents of the exhibit were read in open court is not the issue. The issue is when the court issues an order, everybody must comply with it, and there are reasons for the order. And the reasons, as this court stated, are to protect Mr. Robinson's right to a fair trial. So no doubt that the court balanced those prior ways in which the content of this exhibit had already been disclosed when the court decided that there would not be electronic media coverage. That's a fact that we have all known of that exhibit. That's a fact that we've all been aware of as we've gone along. So to summarize, and then I will stop because I know we still have a witness here, and of course the court needs to hear from the state and counsel for the media, I suspect, is we would like the court to reconsider its order denying Motion 305 and grant it for the balance of all of the proceedings in this matter, or as an alternative, the court prohibit any further electronic media coverage of the preliminary hearing, which includes September 1st.
Weddy, that's what we've been doing for the last 5 days, is watching the evidence to see if there's reasonable doubt.
To the state and then to the media.
Yes, Your Honor. As to the remedy, we've heard of instances where the media has been able to delay publication of the recordings of the proceedings. We've heard of instances where that has been a short delay of like 30 seconds. I've talked to the media attorney about this, and they do not have the capability to do that right now. My suggestion would be for future proceedings to order the media to look into that capability, and that would be a remedy that perhaps could be used in the future. I think that would be a satisfactory remedy to avoid this type of thing in the future. As to the other remedies requested, we have one witness. The final witness, well, the defense has one witness. That witness is a ATF DNA forensic biologist, and I assume that the exhibits that will be admitted through her will be of that nature. We've already, in fact, admitted the report that she is going to be testifying to. The reports, I should say, that's exhibits 30 and I believe 34. And so I don't think we have, and those have already been published, I don't think we have the same risks or, I'll just say risks with her testimony as we do with some of this other evidence that has already been admitted.
Thank you. To the media.
In a proceeding like this, the parties in the court and the media are working together to learn and to refine their processes. I hear Mr. Novak's remarks about challenges that we've run into in the past. I recall, it hasn't been that long ago, a time when the camera was placed in a location in the courtroom that was causing challenges. The court moved it. When there were challenges with aspects of the court's ruling, the court reiterated those, and those processes improved. We are getting better at this. Media is on board and recognizes the court's obligation and its significant efforts to balance the interests here. In light of the court's ruling, including its recognition that the media operator in this case beat almost all of us to the punch, right? And saw what was happening on the screen and moved away as quickly as they could. We believe that the procedures that the court currently has in place, even if they don't, every moment of every hearing, deliver the result that we are intending to deliver. Those processes are working. I don't believe that a further adjustment, much less a sanction, much less a revisitation of something that says let's keep every photographer, every camera out of this courtroom for every proceeding. In light of the court's well-reasoned and exhaustive rulings after long briefing on all of this, the court is currently balancing these interests correctly, and we therefore ask the court to allow the parties to recognize that the time we're dedicating this morning represents a reiteration of the importance of these principles. The media and the parties all recognize that, and we'll continue to endeavor at all times to do all that we can to ensure that those are adhered to, and let the parties go forward under the current procedures without further order or sanction by the court.
Thank you. Any further arguments before the court issues its ruling?
No, but thank you for the opportunity.
Thank you. And just
I don't have a count of trials, but I've
updating
done
my notes.
1,800 live streams.
I'm intending to issue this ruling right now. I'm just making sure that I'm capturing all the points made in the argument right now.
I don't know how you can punish the media for something that wasn't their mistake, but here we go. Scroll to the top and read. I think honestly the solution to this is pretty simple. If it's shown in open court, it should be shown on the TV. If anyone from the member of the public can come in and see that, the media is the eyes of the public. If you don't want it shown to the media, don't show it in open court, period. I don't like how in this case they've divided the public and the media, as if they have competing interests. Watching the sound meters jump on my streaming monitor. As the judge hits the space bar. It's his loud key. I think we are seeing a sanction here. Judge has a stern face here. So let it be written, so let it be done. Tap, 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 tap. Okay. There we go.
All right. I'm almost done. I appreciate the party's patience.
If this turns into a sanction,
This issue rises to the level that necessitates great care. And as my practice, I don't like to rush or make snap decisions. And I want to give this the full analysis that it's due. So thank you again for your patience.
if this does end up being a sanction on media and losing video coverage of the trial, I think we need to hire a shorthand transcriptionist to be there in court to write down verbatim everything that happens so we can do our own transcript, because that's allowed. They showed a letter that Tyler Robinson sent to Lance.
The court will issue its ruling on the request by defense. The constitutional rights of Mr. Robinson and Ms. Kirk are paramount. Although transparency in judicial proceedings is a fundamental interest, it must be balanced against the constitutional rights of all parties. Having considered the arguments presented by counsel and having reviewed the events that occurred yesterday, the court finds that its order prohibiting the publication or broadcast of Exhibit 16 by the media camera was violated. The court agrees with the defense this constituted a violation of the court's order. Compliance with court orders is essential in all proceedings and is of particular importance given the nature of these proceedings. With respect to defense's request as a sanction that the court reverse its ruling on defense motion 305, motion to exclude cameras, the request is respectfully denied. The analysis underlying the court's prior ruling remains unchanged, and the court adheres to its reasoning and conclusions. With respects to the defense's alternative request as a sanction to prohibit all cameras and electronic equipment from today's proceedings, thereby preventing the electronic capture of the proceedings for those inside and outside of the courtroom, the request is granted in part and denied in part. Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order. The court reserves this sanction as it relates to September 1st. It is not before the court. There has not been a request for electronic media coverage, and the court won't issue a pre-ruling. When it becomes, when that request has been filed and all the deadlines which the court has imposed in regards to the MC filing are in place. If motions are filed, the court will entertain motions in brief argument ahead of the September 1st hearing and address it at that time. This is the ruling of the court. Thank you.
And the camera
Turning
gets
to
shut
the
off.
defense, if you wish, you may call your next witness.
Judge, we would like the benefit of the record before we start taking evidence today.
Yes, Mr. Grenander, and I'll allow all parties, given the ruling of the court, briefly.
Okay,
I'll
so
be brief, Judge. And this is in relation to the continued taking of evidence today. And I'll start my statement, Judge, with something that was very insightful that you said the other day. You mentioned, and I quote, "Sometimes you need to take time to save time," close quote. And so that's my purpose for standing up here this morning. We have spent the better part of a day, a little over 5 hours, I believe, hearing from witnesses that the defense has called at this preliminary hearing. And no doubt the defense is entitled to call witnesses at a preliminary hearing as allowed by the rules.
It's
But
just
I think
for
it's
exhibits.
important that the court remind all parties about the purpose of this hearing. This is a probable cause hearing, as Your Honor has repeatedly stated. The defense has invoked the term reliability many times. And the court, frankly, has found the evidence that's been admitted, the testimony. As a gatekeeper, the court has found it reliable. It's been presented. The exhibits have been found reliable. So any questions of additional reliability are really questions of credibility of the witness and weighing of the evidence. And that is not really what this court engages in at the probable cause standard. And so this is all couched in the context of a likely forthcoming standing objection that the state may lodge if the testimony is long and drawn out and exceeds the scope of the preliminary hearing, gets into areas of a 702 hearing, possibly even trial. We will lodge this objection, but I wanted to just simply state the authority, Judge, behind our objection if we do make that. As your court is well aware, the magistrate at this stage of the case must view the evidence in the light most favorable to the prosecution. And that's cited to in a number of Utah cases, to include State v. Schmidt. Schmidt continues, "This means that when reasonable inferences from the evidence cut both for and against the state's case, the magistrate lacks the discretion to choose between them and must leave such a determination to the fact finder at trial." A few other cases I would like to refer the court to. State v. Pledger, which is a Utah 1995 Supreme Court case. Speaking of this standard, the court says, "The standard bars the magistrate from requiring the prosecution to address or even eliminate alternative inferences that could be drawn from the evidence in favor of the defense." So even assuming the defense scores points today in calling these witnesses, again, the court cannot really weigh those
this is the state
in
prosecution.
favor of the defense. State v. Hester, which is a Utah Court of Appeals case 2000, where there is conflicting evidence, quote, "The magistrate may not sift or weigh the evidence, but must leave those tasks to the fact finder at trial." Of course, we're not at trial yet. State v. Virgin, a Utah 2006 Supreme Court case, indicates that a magistrate may only disregard evidence at a preliminary hearing if it is, quote, "so contradictory, inconsistent, or unbelievable that it is unreasonable to base belief of an element of the prosecution's claim on that evidence." There's a State v. Drozbecki case, which is a Utah Court of Appeals case 2010. Magistrates may only disregard or discredit evidence that is wholly lacking and incapable of creating a reasonable inference regarding a portion of the prosecution's claim, but must leave all the weighing of credible but conflicting evidence to the trier of fact. And finally, State v. Lopez, a Utah 2020 Supreme Court case. Speaking of this probable cause standard at a preliminary hearing, the court said, "Under this low bar, it may be difficult for the defense to overcome a prima facie showing of probable cause. Even an alleged victim's recantations may sometimes be insufficient, given that the magistrate must view all evidence in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution," close quote. Judge, Your Honor has heard 4 days of testimony now. The evidence is overwhelming. It's devastating. And the question needs to be asked, the purpose of continuing with testimony if it's long and drawn out. Of course, the defense has the right to call witnesses, but it needs to be within the context of this preliminary hearing. So again, we may be lodging a standing objection of relevance and exceeding the scope of this hearing. That's my record.
Thank you, Mr. Grunander. Do other parties wish to be heard?
It's Mr.
As it relates to
Grunander.
Mr. Grunander's statement.
Not Mr. Ballard, but.
To the defense?
I'm not sure what was being requested by Mr. Grunlander. As I indicated to the court during the testimony of the last witness, we had discussion with the state prior to the start. We had a scheduled date for the court to rule on objections. And the purpose of that hearing was so that we wouldn't have to fly witnesses out from the East Coast if there was going to be a standing objection. Prior to that hearing taking place, the state contacted us after they had participated in interviews of Ms. Oliver and the other experts, and indicated to us, and we indicated to the court, that there was going to be no standing objection to the testimony of these witnesses. So if he's lodging a standing objection now, I think he's waived it, or he should be stopped from asserting it given the circumstances. I didn't hear that he was asserting that, and I intend to keep this next witness focused on the issue that I think is relevant, which is the state presented DNA reports through a non-expert. They selectively read into the record a portion of those reports which left an extremely misleading impression of the significance of that evidence. So I have the author of the report here, and I'm going to hopefully educate the court on what the limitations are of the report, and that's it. I hope to be done with the witness by noon, direct and cross.
It's an hour and a half.
And that will be the end of it.
All right, thank you, Mr. Burton. And before I have you call the witness, just want to make sure that the media had I'm not sure if the media needs to be heard on Mr. Grunander's response. No, Your Honor. All right, thank you. All right, Mr. Burt, you may call your next witness.
Thank you. Call Ms. Oliver.
One last witness. It sounds like the state does not like what they're about to
Ms.
hear.
Oliver, if you'd like to come forward and be sworn in.
They've asked for the judge to basically say, invoke the mercy rule, say enough is enough, I've heard enough. We're going to end this now before hearing this testimony. Which would mean that this is probably the best evidence we're going to hear in favor of the defense right now.
And there's a water bottle to your left if you wish. And after you're
Thank you,
seated,
Your
if
Honor.
you wouldn't mind adjusting that microphone, bringing it close to you.
Not a
to pick up
sponsor.
Your testimony from today. Mr. Burt, your witness.
Thank you. Could you tell us your name, please?
Caitlin Oliver, Oliver.
And Ms. Oliver, could you bring that mic a little bit closer, so I want to make sure your voice is projected. Thank you. What do you do for a living?
I work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives as a DNA section chief.
And how long have you held that position?
I've been a section chief since January, and I've worked with the ATF for about 9 years. Prior to that, I was a forensic biologist.
And where were you a forensic biologist before you started to work for the ATF?
Prior to the ATF, I worked for Jefferson Parish Sheriff's Office in New Orleans, Louisiana, as a DNA analyst and a DNA quality manager.
Back in September of 2025, what were your duties and responsibilities?
I was a forensic biologist.
And do you recall that around September 11th, you received a request to do some DNA work at the request of the state of Utah?
Yes.
Could we display State's Exhibit 30, which is in evidence?
We can't see it. We're prohibited from seeing exhibits today. BATF has always, included explosives as well, and oh, I didn't anticipate this. We're muting the mics while we talk about exhibits. That's compliance on the next level. I think that's even more than the judge allowed, instead of just not showing the exhibits. Well, we have an hour and a half to look at the judge. All right, I will go on my little soliloquy, my little complaint again. I think the judge messed up media coverage in this trial. He's laid a foundation that is just it's a setup for failure. First of all, it sets the state up for failure. It sets the media up for failure, and it definitely sets transparency up for failure. By instead of issuing a rule saying, hey, this is a public proceeding, I recognize Utah state law on this one, it is what it is, and if there's any exceptions to that, we'll address them. He's set this up to be the running battle throughout, as he hits the bottle a little earlier, the Pierre water a little early. He set this up to be a running battle throughout the case, with every exhibit and every witness and every item, every element, every hearing of this case is now also a media battle where we're refighting the same thing over and over, and basically, starting from scratch. Any ground we gained previously is erased at the end of that day, at the end of that hearing, in the end of that exhibit, and we restart. I think that misses the intent of the law in Utah regarding transparency. The presumption of openness is gone. It's gone because now we're arguing to open each item as if it's flipped the burden. Actually, it's flipped the burden regarding this. So, and I hate to say it, but it's wasted already tens, if not hundreds of thousands of dollars of lawyers and court and time. We've had entire hearings scheduled because of this battle, which could have been decided once and for all early on under the law, in accordance with the law, and preserved the rights of Mr. Robinson to have a fair trial.
For instance, the next sample down, 1.2, where the state read paragraph D, admitted paragraph F, you state in F, based on this calculation, there is evidentiary support for the inclusion of Tyler Robinson, correct? As a possible contributor.
Correct.
Mr. Burt, I just want to interrupt.
Sure.
I was made aware of a question about the media as it reflects this order. So the question was whether audio could be transmitted, and my ruling covered the video display of any exhibits. And so I just want to make sure that's the understanding of all the parties, that the audio of your portion discussing evidence is that you understand that that's going to be captured by the camera and displayed, but not any exhibits displayed. Is that your understanding?
That is my understanding of the court's ruling, yes.
And to the state?
Yes.
And to the media?
Yes, Your Honor. There might be concern about the actual monitors, the council table, and the podium. Any clarification on that?
Well, that's why I give my notation at the beginning of the morning that the parties are responsible to monitor their monitors, and that's there because they're entitled to view it, but they're responsible to ensure that the monitors, as the camera is picking up the courtroom, it's directed not to focus on the monitors, but inevitable capture may occur, and that's why that instruction is given.
Your Honor, Jeff Nine on behalf of the victim representative. We cannot see the court from where we're sitting, so I don't know if there's a way for us to view the monitor.
Ah, that's an issue.
I don't understand what you're saying.
It's not being published on this one.
It's not being published on the monitor to the court's right.
Right. The order of the court based as a sanction is no exhibits will be displayed.
In the courtroom entirety?
As it stands right now, yes, that's correct.
Well,
Okay, please approach the lectern.
Okay, now we have the victim's lawyer objecting because they have
Your
a
Honor,
right to-
it's just hard for the victim's family to be able to follow the evidence if everyone but the victim's family is able to view the exhibits here in court.
Thank you. I appreciate your concern. This monitor is not on either. So it's only the attorneys. The attorneys have a right to view what exhibits are being displayed, to make their motions, objections, and to see it. It is the court's discretion on what's displayed in the courtroom for publication, and the court issued a sanction given the events of yesterday, and that's the court's ruling.
Your Honor, I just asked the court to consider that the victim has the right to be present, obviously, at the hearing. And the presence without being able to see the exhibits, again, it's our position, is not meaningful.
Thank you. I appreciate your concerns. Mr. Burke.
Yep.
Could you redisplay Exhibit 30, please? And again, while he's doing that, that same conclusion where you include the language, go back to that page, please, 5. Use the term, there is evidentiary support and possible contributor. I want to focus your attention on the words evidentiary support. We've had a prior witness testify that, from the FBI, testified that they use a scale and they characterize the support along the lines of strong. Are you familiar with that type of a scale?
Yes.
Does your agency employ that scale?
We can come to 5 conclusions at our agency, so there can either be exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion.
And I take it from what you just said, you don't use these qualifiers strongly. The words strongly include things of that nature.
Yes, we don't use a verbal scale at our laboratory.
Is that a scientific phrase when you talk about instead of saying that there's support for an inclusion, you instead say there is strong support for the conclusion?
So our laboratory doesn't use a verbal scale due to the fact that they add subjective words to the front of this word support. It is our stance that the likelihood ratio statistic, the number stands on its own. So we report the likelihood ratio and either support for inclusion or support for exclusion.
Thank you. Would you go to page 8 of the report and highlight the very top of the first 2 sentences? You included this language in your report, correct?
Correct.
And in fact, you included this language in all 3 of your reports, referring to the conclusions conform with the relevant Department of Justice policy on uniform language.
That's correct.
Right. And why do you include that language in all 3 of your reports?
It's standard language for our reports. Our reports adhere to the DOJ Ultra statement.
Okay. And could you go now to Exhibit Oliver 4 for the witness only? Not admitted yet. Are you familiar with this document, the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examination using probabilistic genotyping systems?
Yes, I am.
Right. And would you go to page 4 of that document, please? And the court has heard some prior testimony about this Department of Justice directive. What is ATF's, what is your understanding of what the qualifications and limitations are that are required by this policy of the Department of Justice? What are you not supposed to be saying in connection with the reports that you wrote in this case?
There's a few things that the Ultra document states. First, it states if you use a verbal scale, which we do not, then you need to use the one dictated in the document. This is in an effort to unify the language coming out of DOJ laboratories. It also says that we cannot state that our evidence is infallible, nor can we state that there is a inconclusive result.
Shall not state that it's infallible or have a 0 error rate, correct?
Correct.
It also states, does it not, that you shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample.
Correct.
And are your reports in conformity with that? You're not stating or implying that anything you did here is asserting an absolute identification of someone as the source of any of the evidence that you examined, correct?
Correct. With forensic evidence, it's impossible to state with 100% certainty anything. That's why we report a likelihood ratio, to speak to that uncertainty with a statistic.
All right, and would you go to the next page of that document? This policy requires that you not state or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty. You didn't do that in any of your reports, correct?
Correct.
You're not asserting anything with respect to any reasonable degree of scientific certainty.
Correct.
Correct. Now, when you can take that down. When did you first receive the assignment in this case?
I would have to refer to my case record to know the exact date.
Do you have those in front of you?
I do not.
Okay. Let me pull up Oliver 3 for the witness only. And go to the third page. Does that third page help refresh your memory on when you may have received this case?
Yes, on September 12th, 2025.
Okay. Is that when you first started doing work on the case, do you think?
Yes, it is.
Now, prior to doing work on the case, did you receive permission from someone to consume any samples in the case?
Yes, I did.
And could you go to page 15 of those case notes, please? Again, for the witness only. Do you recognize this email?
Yes, I do.
And can you tell me what the email is and what information it conveyed to you in connection with your examination?
Yes, so it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent. We request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So this email is us receiving permission to consume the samples and move forward with testing.
Now, does your lab have a policy for preserving samples for independent testing by the defense?
Where possible, we will not consume samples where it's possible.
And that policy is a longstanding one, not only in your lab, but pretty much everywhere in forensic DNA analysis, right?
That's correct.
Goes back to 1996, does it not, when the National NRC recommended a policy that samples be split wherever possible at the front end of the analysis to allow for independent examination.
Where possible, yes, that's correct.
Right, and they did that because it was their conclusion, was it not, that a wrongfully accused person's best insurance against a possibility of being falsely incriminated is the opportunity to have the testing repeated. Such an opportunity should be provided whenever feasible.
Correct.
Okay. Could you now go back to Exhibit 30, page 8? Were certain DNA samples consumed in your analysis?
Yes, they were.
And for the record, are those listed on page 8 of your report?
Yes, they are.
Which samples were entirely consumed in your analysis?
That would be exhibits 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, and 5.1.
Okay. Then are there a number of samples listed above there in the report where you say the DNA extracts will be retained? And then you list 1.1, 1.2, 1.3, 1.5, 1.7, 1.8, 1.13, 7.1, and 8.1.
Correct.
Does that mean that those are all swab samples, correct?
They were swabs, yes.
All right. Does your report mean that you consume the swabs, but you have some liquid extract remaining as to those samples?
Correct.
Now, are all of the samples, let's talk about the samples in Plaintiff's Exhibit 30. Were all of the samples you looked at there mixed samples?
Did I refer to my tables in my report?
Sure. Go to page 2, please.
And can we go to page 3 and 4?
3 and 4, please.
With the exception of the known samples from the known individual, that was a single source sample, but otherwise the evidence samples were all mixtures.
And in many cases, they were mixtures of sometimes 4 and 5 people, correct?
Correct.
Now, when you look at mixtures, such as the ones in this case, you use terms like major and minor contributor, right?
Correct.
Is that language meant to convey that anything with respect to activity of anybody who might be assigned to that DNA weight? In other words, are you saying the person you label as a major contributor was engaged in any sort of activity? Is there any connection between the use of that language and activity?
None of the testing that I performed could speak to activity or what activity led to the deposition of the DNA.
So nothing in your report, if somebody reads that and says, oh, this one says this person is a major contributor, you're not commenting on anything about the person's activity, correct?
Correct.
And is it true also that there are also several other limitations concerning the language of your report that it's important for courts and people who are reading the report to understand?
I'm sorry, what was the question?
Are there other limitations in addition to the one we just reviewed that it's important to understand about the language you use in your report?
In terms, is there something specific that you're?
Yeah, there is. Could you go to?
I'm waiting for the smoking gun that's going to drop here, and I'm not
Exhibit
seeing
30,
it yet.
page 1, for the witness only. Are you familiar with this publication?
Yes.
This is a publication by the National Institute of Standards and Technology called Forensic DNA Interpretation and Human Factors.
Yes.
Correct.
This is put together as a guidance document for practitioners on what, to simplify, essentially, what to say and what not to say.
I don't know that I would call it a guidance document. NIST is not a regulatory body for DNA testing. It was a report that looked into forensic DNA reporting and specific human factors that could affect our testing. So they may have had recommendations, but as far as them being a regulatory body that's issuing guidelines, I wouldn't state that.
Okay, that's fine. Could you go to 136, please? 136. This is Baker 30. Keep going. There we go, right there. Wait, 135, I'm sorry. And then scroll down to the next page. So they're making recommendations here as to how the report should be worded, correct?
Correct.
Let me ask you whether you agree with some of these limitations, or they call them caveats. They talk about how you describe the number of contributors, and they say the true number of contributors of DNA to an item can never be known. Do you agree with that?
Yes.
Okay. They also say, let me ask one question before I ask this one, which is, do you use something called a reporting cap in all three of your reports?
Yes, so for our likelihood ratio statistics, we cap the statistic at 1 trillion. The actual number could be a lot higher. It could be quintillion, octillion. We chose 1 trillion because it has meaning, I think, to people that can understand what 1 trillion is. An octillion and a quintillion gets a little high at that point, so we cap at 1 trillion.
What ain't left the sanctions?
And
We
they
can't
talk
see
here,
the
do they
exhibits
not,
today.
about how you convey the idea of a reporting cap, and they say the LR reporting cap was chosen because of the limitation of biostatistical modeling and independence assumptions of STR loci. Do you agree that that's why the cap is chosen?
I believe we chose our cap for the reason I stated.
Do you disagree with that statement in terms of why the cap is chosen?
I'm not familiar with the paper that's referenced there, so I would have to familiarize myself before I said I agreed or disagreed.
Fair enough. And then they also suggest that you alert in your report that profile descriptors cannot be applied to activity level issues. Do you agree with that?
Yes, so this is what you were stating about calling a major contributor. It doesn't speak to the activity that led to the DNA deposition.
Right. DNA profiles may be described as major, minor. However, these descriptors should not be interpreted in the context of a decision regarding the nature or the mechanisms, actions, or timing that led to the deposition of the DNA. You agree with that?
Correct, yes.
All right. And then the other sort of limitation, convey that the DNA results cannot be interpreted as the analyst providing an opinion regarding who the source of the DNA is.
Yes, so this is, once again, we don't make source attribution statements. We will say there's support for inclusion, and then we back up that with a statistic.
So from a scientific standpoint, you couldn't read the paragraph that sets out the likelihood ratio in your report, whatever the number, and then blast a headline in the media, Mr. Robinson's DNA is found on this item. That's a source attribution, is it not?
Correct, yes.
And that would not be scientifically defensible, would it?
Correct.
Okay. Another limitation they talk about on likelihood ratios, on the next page, please, 137. Likelihood ratios cannot speak to the likelihood of a proposition, only to the probability of the results given a pair of propositions. Do you agree with that?
Yes.
Explain that, because that's a little above my pay grade in terms of understanding.
So a likelihood ratio statistic compares the probability of the DNA profile of the evidence given two competing hypotheses or two competing scenarios. Typically, the first is that the person of interest is included, and then the exclusionary hypothesis would be that the person of interest is excluded, so there's a random, unknown, unrelated individual contributing.
And when they're elaborating on that point, they say a likelihood ratio indicates if and to what extent the DNA analysis results support one proposition over another. It is not possible on this basis alone to determine which is the most probable proposition. Do you agree with that?
Yes.
Okay. And then the next limitation they suggest you convey is that convey that DNA statistics cannot imply uniqueness within a population. Do you agree that that's a legitimate limitation?
Yes.
And explain what that means. Does that go back to the issue of source? You can't assign a source to a DNA sample?
Correct.
Okay. It says you should delineate the meaning of a verbal qualifier, but you didn't use one in this case, right?
Correct.
Okay. Now, you mentioned that your testing cannot, and correct me if I'm wrong, I don't mischaracterize it, your testing, none of the testing in any of the three reports can answer the question of how and when DNA got deposited. Is that true?
That is true. DNA can't speak to the activity that led to the deposition of the DNA.
And the report says, with regard to that issue, with the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swabbed. Alternatively, a person's DNA may be present when they were not involved in the crime. Do you agree with that?
Yes, once again, I cannot speak to the activity.
Can you explain how it's possible that a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swabbed?
So it's possible if, say, the pen that you're sitting there using for the week, you, say, hand it off to the judge, and the judge then touches it for a period of time, and then I swab it. It doesn't speak to who handled it last. I could test that. I could get both of your profiles. I wouldn't know which person was the last person to handle that item.
All right. And similarly, if you had a lot of DNA on your hand, we shook hands, I then went to pick up an exhibit, a gun, I touched the trigger of it, your DNA could be on that trigger, right?
It is possible, yes.
Okay, even though you never touched the gun.
Yes.
And that's why, because of those possibilities, you can't make any assessment of how or when DNA got deposited, correct?
Correct.
How long can DNA persist on an item?
DNA is quite stable over time. It can be broken down due to environmental insults, so things like heat and humidity are known to break down DNA over time. But I couldn't give you an exact number.
Were certain of the samples that you tested in this case degraded samples?
There was degradation present in some of the samples.
And what can cause degradation?
Like I said, there's environmental insults, heat, humidity.
Now, the second report that you wrote had to do with a Dremel item that was taken from Mr. Robinson's home?
Correct.
And did you request certain what are called elimination samples in regard to items that were recovered from his home?
Yes.
Tell the court what an elimination sample is as opposed to a sample that relates to what's called a POI, person of interest.
So an elimination sample is a sample taken from a known individual that it may be assumed that they could have come into contact with it. If I were to say swab your vehicle, then I would want your DNA sample as an elimination to eliminate you in order to look for any additional DNA that may be there.
And you say they're assumed contributors because depending upon the location, for instance, somebody's house, you would expect if there were multiple people in that house that perhaps everybody in the house could contribute to a certain DNA result.
It's possible.
So you'd want samples from all those folks to see if they contributed to an item that would be associated with a place where they congregated.
Correct.
And I noticed from your case file that you also requested, but I don't think you received, elimination samples from agents who were involved in this case.
Correct.
Why do you request those samples?
The type of testing we perform is quite sensitive, and so it is a standard practice that we request elimination samples from any of the investigators involved in order to potentially eliminate them in case they could have contaminated the evidence.
Okay. Now, in report number 157, if you could bring that up, please. Oliver 157, which has been admitted. The elimination samples that you requested in connection with items seized from Mr. Robinson's apartment were from Amber Robinson, Matthew Robinson, and Lance Twiggs, correct?
Correct.
And that's because you had information that those people were associated with the house.
Correct.
And when you tested or compared, first of all, you determined their DNA types, right?
Correct.
Then you compared their types to what you found on the evidence.
Correct.
And for a certain number of those samples, you found the presence of DNA of your elimination samples, not because they were suspects, but because they were associated with the premises, right?
There was support for inclusion of some of these individuals, yes.
Okay. And if you could scroll down to page 4, which is the table, I just want to review briefly with you. For instance, item number 1.4, which was a swab from the rifle. You used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I would say there's support for inclusion of Matthew Robinson on the sample obtained from the swabs of the bolts of the rifle.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct. And
again, not because he's a suspect, but because he's associated with that premise.
Correct, and there would have been a likelihood ratio statistic calculated and to go along with that.
Okay. Could you go to the next page? Similarly, with respect to 1.6, you found, again, Matthew Robinson on swab number 1.6, or a profile that indicated he was a possible contributor.
There's support for inclusion of Matthew Robinson.
Okay. And next page, actually go page to page 7. You found support for inclusion of Lance Twiggs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twiggs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twiggs's DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
And similarly, you found profiles to suggest support for inclusion of Mr. Twiggs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area I want to ask you about is, you're familiar with something called NGS?
Yes.
What is NGS?
NGS stands for Next Generation Sequencing. It's a DNA technique that sequences your DNA, so it looks at the individual sequence of your DNA.
And is it true that in your field, that whole area of NGS is something that's at the forefront of everybody's attention? For instance, when you go to seminars and you look at the presentations, there's a lot of talk about NGS, right?
That's correct. Yes, it's a newer technique.
And is it being developed by ATF as a technique that's going to be used or has been used?
Not at this time, no.
And is there plans to do that?
Not at this time, no.
Okay. Do you know if other labs have implemented it?
I believe there may be some laboratories in the United States that have it in use, but I wouldn't have direct knowledge of that.
Now, you used a program in this case called STR Mix, correct?
Correct.
And that's sold by a company in New Zealand, that software?
Correct.
Have they developed another program called STR Mix NGS?
I'm not aware of NGS software.
Could you go to 156, Oliver 156? Let me know when you're there. Are you aware that the developers are selling a product called STR Mix NGS?
I was not aware, no.
Okay. Now, sequencing analysis is different than what you did in this case, correct?
Correct.
And how so?
As I said, sequencing is looking at the individual sequence, the individual bases that make up your DNA, as opposed to the testing that I'm performing, which is looking at length variations. So STR testing, which is the testing I perform, looks at areas of the DNA that are known to be highly variable between individuals, and there are areas where the DNA sequence repeats itself over and over again. And depending on who you are as an individual, you may have a different number of repeats present at that location. So the testing we're performing is looking at those length variations. There's a distinction between, say, if you have 10 repeats versus 12 repeats.
But you're not looking within those lengths to see what the sequence of the DNA is.
Correct.
And that's what this new technology is designed to look at.
Correct.
And the reason it's designed to look at that is because it's been found that there are DNA areas that are different in sequence, even though they're the same length. Is that true?
I think the reason for developing NGS software is to add another tool to a forensic biologist tool belt.
Okay. Now, could you go to 154, please, for the witness only? You're familiar with this chart?
Yes.
Okay, this lists all the alleles that you found for all the testing in your 3 analysis, correct?
No, it looks like,
no, you were right, 154. Yeah, this is one. What's the exhibit on this?
This is 154 in the second page.
Okay. You're familiar with this chart, right?
I've reviewed the first page of this chart. I have
Sure.
not reviewed the entire
Go to
thing.
the first page. This lists the alleles that you found, correct?
For the known samples, yes.
Okay, now go to the second page. And is it true that for the alleles of interest in this case, one of the alleles of interest is at the D3 location, allele 17?
One of the locations that we look at on the DNA strand is called D3. That's a location, yes.
Right, and in this case, the 17 allele is important because Mr. Robinson had a 17 allele, correct?
Correct.
And some of the evidence had a 17 allele.
Correct.
At that location.
Correct.
So as I understand the way you do this, you look and compare whether those are the same number, basically.
I wouldn't state that's how we do our comparison. So it's not just number matching. We're using STRmix, the StarMix software, in order to perform an analysis of the software that looks at the possibilities for a DNA profile and make comparison to the knowns that way. We aren't using a chart and just doing number matching.
Yeah, and I wasn't suggesting you did, but you're looking at the alleles and measuring the peaks, and it's a fairly sophisticated process, correct?
Correct.
But the bottom line is you're comparing alleles one against another.
Correct.
So if a person is a 17-17 and the evidence sample is a 17-17, you're looking at that comparison.
Correct.
And again, measuring only length.
Correct.
But it's true, is it not, that researchers have found that that particular allele, the D317 allele, that there are actually 3 different 17s, 17A, 17B, 17C.
Yeah, so there's something known as isoalleles. What that is you may have, in this case, a 17 allele, but the sequence within that 17 allele is different. So 2 people may have a 17, but they may have a different sequence within their 17 allele.
And it's been found that there is a 17A, a 17B, and a 17C, correct?
Objection. Relevance to the probable cause hearing. At this point, I think we've once again gone beyond probable cause, and based on Mr. Grunlander's argument, I would invoke his argument here in the case law that he referenced, and I object to this question.
Let me withdraw the question, reframe it, and move beyond it.
All right, so I'll sustain the objection. It will be reframed, and we'll go from there.
It's true, is it not, that at least 1, 2, 3, 5 of the locations of interest in this case, researchers have found that the alleles that you were looking at, these isoalleles, have different sequences but the same length.
Objection. Relevance. The witness has testified she does not do sequencing analysis here, and that's what the question is asking, is about sequencing analysis.
Counsel?
The point, though, is that her testing cannot distinguish between these isoalleles, and therefore it goes to the weight of the comparisons.
But if she didn't do that?
Yeah, that's the point, is that she didn't do it, and therefore she's not in a position to draw conclusions.
Mr. McBride?
That proffer is inaccurate, that she's not able to draw conclusions because she did not do NGS or sequencing analysis. She has testified that her lab and the analysis she did here is not sequencing analysis, it's something different. Whether or not she could do sequencing analysis is irrelevant to the analysis that she did do. If Mr. Burt wants to call an expert to say sequencing analysis is better or something like that, that's fine. But this expert does not do sequencing analysis. Therefore, the line of questioning that goes into sequencing analysis is irrelevant to her testimony.
Let me see if I could lay a further foundation.
All right, so I'm going to sustain the objection.
Sure.
And the question may be re-asked if counsel chooses.
When you do your analysis using length only, do you go by the rule that if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and reference sample is usually declared a non-match, regardless of how many other loci match?
No, it's not quite that simple. What you're speaking of is an exclusion, is that correct?
Yeah, right.
So it's possible for DNA evidence we spoke about, it's possible that DNA evidence be degraded. In a case like that, there may be the potential that some of the profile has what we call dropped out. So it's not present. In that case, we wouldn't expect necessarily to have a inclusion or exclusion at that location because there's no information present there. So it's not quite as simple as is every allele in this chart present in the evidence. There's more to it than that.
If you had a difference in sequence between a known and a question across many loci, would you exclude the person?
It depends.
Again, objection, Your Honor. We're going back into sequencing, which is not the analysis that was done in this case.
Mr. Burt.
Again, Your Honor, if there could be an exclusion based on this and the testing was not done, I think that is relevant.
But as it relates to this witness and her firsthand knowledge, I'm not seeing that tie-in as it relates to her.
All right, let me move on then.
So I'll sustain the objection.
Now, you said that all the samples you looked at in that one report were mixtures, correct?
Correct.
And the number you get in the likelihood ratio depends on how many contributors you estimate, right? The number is going to vary if you say I think it's a mixture of 2 people versus I think it's a mixture of 5 people.
It's not necessarily the number of contributors. The likelihood ratio speaks to the weight of the evidence. And so it's comparing known individuals to the unknown sample. It could be a low number and be a single source sample. It could be a high number and be a 4-person mixture. It's not necessarily directly correlated with the number of contributors.
Let me ask you if you agree with this. This is from the NIST mixture study. A likelihood ratio numeric value is not a measurement of a physical quantity. Do you agree with that?
Correct.
Rather, it is a ratio of probabilities in the opinion of the expert assessing the likelihood ratio and is dependent on the specific propositions used to formulate it and also on the individual making the assessment.
Correct. Yes, I agree.
And does the final likelihood ratio depend on the number of contributors you assume?
$5 says
No,
he
it
didn't
does
write
not.
that assessment himself.
It has no effect whatsoever.
That question.
It can have an effect. It's possible. It's possible multiple other factors could contribute to the likelihood ratio.
Is it somehow difficult to figure out how many contributors there are in a sample?
I guess I would say that I use my my training, education, and experience in order to determine the number of contributors present in a profile.
Well, I noticed throughout your report you used the phrase, for instance, with regard to the 1.2 sample, the profile consistent with at least five contributors, at least one of which is male. And for 1.1 you say the profile is consistent with at least 4 contributors. I assume by the word at least you're signaling that it could be more.
Correct.
And as the number of people to a mixture increases, the difficulty in sorting out that mixture increases as well, correct?
Correct.
I noticed in your standard operating procedure there's some guidance on interpreting 3-person mixtures. Familiar with that, right?
Yes.
And it says, and correct me if I'm wrong, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
It's possible for them to present, yes.
Well, it doesn't say it's possible. It says, for example, approximately, in all cases, assuming a mixture as a result of the combination of 3 people must be done with caution. For example, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
You said you're referencing my SOP?
Yes,
Is it possible for me to take a look at it?
sure.
Your Honor, I'm going to object at this point. The point that defense counsel is getting at is made in the last answer, which is that the difficulty of sorting out mixtures increases as the number of contributors increases. That's all understood, but that has nothing to do with the probable cause determination. Even if it's difficult, the inferences and the evidence is weighed in the favor of the state. The court cannot weigh the difficulty in determining this evidence. Is it fair for a trier of fact at a jury? Sure it is. But we're now getting into weight issues that are relevant for a jury, but not for this court.
Well, he's implying this is going to be an extended discussion. I have one question which he wants to look at her manual to make sure it's in there. So, and then I'm done.
All right, I'll allow this question, so I'll overrule the objection. She may review the material and
So could you bring up
question can be rephrased.
one exhibit, Oliver 148?
And then I'm done. Famous last words. And then I'm done. One last question, and then I'm done.
This is your SOP document, correct?
Correct.
And then go to page 83. Did I read that correctly?
Yes.
And so it's true, is it not, that approximately 70% of 4-person mixtures present as 2- or 3-person mixtures?
It's possible.
Thank you. That's all I have.
All right, he told the truth.
We've
One
been
more
going
question.
for a bit, and depending on how much cross, and trying to decide if a break is warranted or if Mr. McBride, you wish your cross is limited. Again, not trying to
Remember
say
in the
which way you should
beginning
go. I'm just
when we
trying to
started?
weigh whether we should take a break.
I will probably be, I'll probably be 20 minutes.
All right, let's just keep
Push.
going, and then at that point, we can take a break. Thank you, Mr. McBride.
Good morning.
Morning.
Is your lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary accreditation process where a external third party comes in and audits our laboratory to a set of standards. Specifically, the ATF laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO 17025 for testing laboratories. And additionally, a DNA-specific set of standards put forth by the FBI.
Does the accreditation require that the methodologies you use be validated?
Yes.
The methodologies used in this case have been accepted by courts across the country, correct?
Correct.
Does the accreditation require that forensic biologists like yourself satisfy certain qualification standards?
Yes, we're required to perform competency testing prior to participating in casework. And additionally, we participate in twice a year proficiency testing.
And do you satisfy the competency and qualification standards required by accreditation?
Yes.
And at the time you did the testing in this case, did you satisfy those standards?
Yes.
Moving to your opinions, where on the firearm did you find evidentiary support for the inclusion of Tyler Robinson?
There were several locations. I'd have to refer to my report.
Okay, would you look at your report? And this is, it looks like report number, or exhibit number 30. If we can pull that up just for the witness.
Do we have it? Are we ready?
We had it for a minute here, a minute ago. Okay, if we could go to page number 2, please. Will you just list off the areas of that firearm where there was support for, evidentiary support for inclusion of Tyler Robinson?
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle, swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging, the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
We go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory.
And page 4.
The swabs of the protected underside of the receiver of the rifle after disassembly. The swabs of one 30-06 cartridge case. The swabs of one 30-06 cartridge. And the swabs of one 30-06 cartridge.
I want to ask you about a couple of those conclusions. Let's look at page 5, please. And calculation number 3, exhibit 1.3, do you know where that swab was taken from?
I'd have to refer back to page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
The 1.3 is the swabs of the trigger and trigger guard of the rifle.
All right, going back to page 5. And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
You say at least 1 trillion times more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But the protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6.
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
And same question there. The trillion number, it could be far less than that, but you stop your calculations or the statistics at 1 trillion. Is that right?
Correct.
Let us move to page 7 with regard to statistical analysis calculation number 7. Now, do you remember what 1.3 or 1.13 and 2.1 are?
I'd have to refer back to page 3, I believe.
You could jump to page 3. Thank you, Kimberly.
Page 4, I'm sorry.
Page 4.
The 1.13 is the swabs of the protected underside of the receiver of the rifle after disassembly. And 2.1 is the swabs of one 30-06 cartridge case.
Now, did you do the swabs themselves?
I did not.
And 2.1 is a cartridge case, is that right?
Correct.
And what's the difference between a cartridge case and a cartridge?
The cartridge is unfired, cartridge case has been fired.
Right. Let's jump back to page 7. And what was your conclusion with regard to, well, first of all, why do you group these two together, exhibits 1.13 and 2.1 in your conclusions here?
They were both mixtures of two individuals, and they both yielded a likelihood ratio of the same magnitude, so they can be grouped together.
Okay. It's not that they were tested together?
Correct.
It's just that the results were of the same magnitude, so they were reported together. Is that right?
Correct.
All right. What was your conclusion as it relates to both of these as to the likelihood ratio?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major contributor and an unknown unrelated individual than if they originated from 2 unknown unrelated individuals.
And did you make a conclusion here as well about a probability statistic?
Yes, so the probability of an unrelated individual in the population who has not contributed DNA to these samples yielding this level of support, so meaning yielding this likelihood ratio, is less than 1 in a trillion.
Nothing else.
Mr. Burt.
We may be done.
The 1.3 sample is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct, so they were swabbed together, so I wouldn't be able to say where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample that that was a sample consistent with at least 4 contributors, right?
Correct.
And did what you term the major profile have the largest amount of degradation in that sample?
There was, yes.
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
Correct.
You can't tell us anything about whether, when you say it's at least 4, it could be 5, 6, or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison, and the minor contributor is not suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing. It has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yes, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30. Right?
You said Exhibit 1.1?
Yes.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay. And again, with regard to all these samples, no way of knowing when or how the DNA got on those samples, correct?
Correct.
You referenced another statistic in your report which is the statistic related to paragraph E, I guess.
Correct.
Is it what's called the random match probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio computation, right?
Correct. It's based off the likelihood ratio computation.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute it to any person. Can't state it's infallible. Can't state there's a zero error rate. And you can't state that it is a source connected with any one person, correct?
Right. So part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
And address the uncertainty along with the other limitations we talked about.
Correct.
Thank you. That's all I have.
Thank you. Anything further for this witness?
Any rebuttal? Any rebuttal testimony from the state?
No.
All right. May this witness be excused? Yes. All right. Thank you, ma'am. You may step down. Anything further from defense?
No, we have no further witnesses.
All right. Returning to prosecution, anything further?
No, Judge, we have no rebuttal evidence to present at this hearing.
All right, we're done.
The state has no rebuttal evidence to present at this hearing. However, before we break, there is the matter that was discussed yesterday with respect to publishing in the courtroom Exhibit 12.1 so that the victim's family can observe that.
Thank you. All right, do the parties wish to be heard as it relates to this briefly, and then the court will issue its ruling. And
Your Honor, I actually just want to make a quick record. We have advised Mr. Robinson of his right to testify at this hearing, and he is choosing to take our advice and not testify.
is that correct, Mr. Robinson? And I note that he's nodding in the affirmative. Thank you, Ms. Visser. All right. In regards to the outstanding issue about the publication of State's Exhibit 12.1 to the courtroom only, to persons here, any further input from any of the parties before the court issues its ruling?
Your Honor, Jeff Nyman on behalf of the victim, my understanding is you ruled yesterday that you were going to play it, that you did grant our request. So I don't know if we...
Thank you.
He's so open.
Judge, I might simply add, given the court's ruling this morning with respect to displaying exhibits, we may want to make a record with the live streaming folks here that it's not going to be published.
Thank you. All right. Nothing further from any of the parties? Okay. Just updating some notes. All right. The court wishes to readdress yesterday's ruling in light of this morning's sanction as it relates to Exhibit 16. The court separately addressed that incident and imposed a sanction on the record. Having considered all applicable public access, fair trial, privacy, and victims' rights interests, the court adheres to its prior ruling. The court finds that temporarily limiting live stream to audio only while Exhibit 12.1 is displayed is necessary to prevent the inadvertent publication of the exhibit from being transmitted to outside the courtroom, and no broader and is taking the least restrictive means to accomplish what is being requested. Accordingly, Exhibit 12.1 may be viewed by all persons physically present in the courtroom, including victim representative Ms. Kirk in her capacity as the victim representative. The same in-court viewing rules applies to all parties and courtroom attendees. And that is the ruling of the court. Let's go ahead and proceed to that, to the stage. So could the camera operator let me know when we're switched to an audio only? We are? Okay. All right. And as it's switched to audio only, to the state, now my understanding there's no audio on this surveillance on 12.1. Is that correct? All right. All right. So let's go ahead and play that. And I'm going to rule that this also applies to the still photographer. It cannot be captured the screen in any way. I noted video recording, but I intend as well as no still capture of any of the monitors during the publication of 12.1. All right.
All right. So now we get to listen to a silent video.
And to the stage, just let me know if you're ready. Let's go ahead and play it now.
This is about, I believe, about a 8 to 10 minute video. 12.1, if I understand this correctly, this is the compilation of security camera UVU footage with zoom ins, with enhancements, with circles, with all the improvements as far as the evidence goes. There's no audio anyway, but we've seen the video in the original form without zooming in on anything. This is the car showing up, pulling into the parking lot. Mr. Robinson going, walking out wearing shorts, headed to Chick-fil-A, eats Chick-fil-A, comes back, goes and talks to TPUSA, Turning Point USA, the organizers of the event. Possibly at that was getting information regarding where exactly Mr. Kirk was going to be during the event. Then goes back, moves his car over into the neighborhood outside of campus, walks back into campus, change of clothes. We've got some videos of him walking with a straight leg or pretending to limp, accessing the roof of the UVU LOSI building, which overlooked the auditorium type area, the event area. Auditorium is the wrong word. The tiered grassy area where Mr. Kirk was doing his presentation, and then he's in place on the shooter's perch on that roof for no more than 30 seconds around the time the shot's taken. Then he appears to get up and run across the building to the far corner where he drops down, hangs from the edge and drops down onto the grass and leaves, crosses over Campus Drive, leaves over into the tree area, which is where the officers later locate the rifle wrapped in the towel. Pavilion area, that's a good area. But I think he was just under, it wasn't really a pavilion, it was a pop-up tent, like a white pop-up, a cheap tent. But the zoom in is going to have bigger pixels. This is not an AI enhanced version of the video. It's just zoomed in, or say an arrow saying paying attention right here. Here's this little black mark. This is what we believe is Mr. Robinson carrying the firearm wrapped in the towel, running across the roof. But if you look closely at the limp video, you can see the firearm in his pants as he climbs the stairs. It's obvious they should blow up that part. Maybe we can. Let's, where would that be? That's going to be on... Do you think, Nicole, do you think it was on the side of his leg, in the front of his leg, or behind his leg? Obviously, between the legs doesn't really work for the firearm, because that would be a bit awkward. see if I can find this. I have to do this. Barely see the screen over there. Magic Cloud. This would have been day 2, I think. Was it 3 that it was shown? I think it was day 2, day 3. Right? What day did they show this? Now we lose the audio too. Don't even get typing now. Had to have been the 9th, right? It was day 3. Day 2, we fought about it all day. Was on the 8th. Yesterday was the Lance Twiggs interview. Oh, this is the video I fixed, right? Yeah. I'm not hitting the space bar hard enough. I'm not typing anything. I'm using a mouse. That's it. I can add to sound by updating the like counter. That can do. Yeah, we only saw the original.
All right, and that concludes the playing of Stacy Exhibit 12.1. Video transmission may resume. Just let me know when that is
thumbs up
live. All right, thank you. Does either party need the benefit of the record?
The state does not, Judge.
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes.
Yes, Your Honor.
All right, we'll make the recording. Thank you.
Mr. Nestor doesn't
The
need the
court
benefit of
appreciates
the
the
microphone.
professionalism, civility, and respect shown by counsel, the parties, and all persons in attendance throughout these proceedings. As there are no further matters before the court, this proceeding is adjourned until September 1st at 10 a.m. Good afternoon to you all.
And bang.
All right.
There we go. With that, we are done with the hearing. It's over. A decision is not being made today because on September 1st, there will be 4 hours of 4 hours. That's a lot of argument, in addition to 6 weeks for the parties to file a written statement, written submission regarding their side. So basically, we're going to write out our closing argument. We have to limit it to 35 pages. State's going to write theirs out first, send it into the judge. They need 2 weeks to do that. 2 weeks from Tuesday, which means Monday they get the transcript, a rushed copy of the transcript of the whole proceeding. And 2 weeks from Tuesday, they'll submit their 35-page or less submission as to, Judge, here's our argument, why we should go ahead and bind over Mr. Robinson for trial, and this is why we proved it. Then the defense gets 2 weeks from that moment to read the state's submission, review the transcript themselves, and file their 35 pages to say, Your Honor, this is why the state has not met their burden, and there's no way you can bind Tyler over for trial because no jury could convict him based on this shoddy evidence that the state has presented thus far, or what they call their sad excuse for evidence. 35 pages. State then gets 18 pages and 2 more weeks to reply back to say, but Your Honor, this is where the defense is wrong. And yes, we did. And then we'll be at September 1st, where both sides get 2 hours to basically do the same thing and argue in front of the judge and in front of Mr. Robinson that we proved it and you know it, and you should go ahead and bind him over for court because we said so. So 35 pages of blah, blah, blah each, then 18 pages of blah, blah, blah in response, and then we still have 4 hours of arguing. And that's going to be some pretty heated arguing. At that point, whether the judge makes the decision to bind Mr. Robinson over or not, at that point, I'm not sure. I don't know if he's going to say, I'll take this under advisement. I think because he'll be reading and following along with the submissions in court, that he should be prepared to make a ruling that day. I think that he will be, especially because Mr. Robinson's going to be there, he'll be bound over for court. I do not see a possible way, especially with the probable cause standard as the bar, that this would do anything other than that. This will be a bind over. This is open and shut when it comes to evidence. You got 3 confessions, right? You've got written, verbal confessions. You have evidence, text messages that can be time-stamped and verified through extractions of cell phones that put the defendant in the area with knowledge only available to law enforcement and the shooter themselves, that corroborate, that say that he was the one. You've got DNA that puts him on the scene. This, for me, as a juror, had this been the actual trial, I would be, beyond reasonable doubt, ready to vote to convict. Now, we get to reset all that and look only at the evidence that comes to trial, assuming he is bound over for trial and assuming he doesn't plead guilty. And we get to reset, and there's an assumption of innocence as the jury takes the stand, and we'll do that again. We'll reset ourselves, set everything we know about the case aside, and listen only to the evidence that's admitted into court, because it will be different evidence, right? A lot of the hearsay, reliable hearsay, that was allowed in this one will not be allowed in trial. We'll have to get that evidence directly from the witness. We will see Tyler in court. We will see Lance in court. Tyler probably won't take the stand during trial either, like he didn't this time. But we might hear from his parents. We might hear from the scoutmaster. We might hear from, definitely going to hear from Lance in person. All of that. But as far as when this takes place, with these additional 6 weeks, I can't see this taking place this year. September, October, November, December, 3 months to go from a bind over to court, even on speedy trial, and which Mr. Robinson waived only in relation to this submissions for preliminary hearing. He hasn't fully waived his rights to speedy trial. This puts us in 2027, minimum, bare minimum, and maybe even mid-summer 2027. Phoenix Feather, what's your question? It's all about negotiating the death penalty away with a plea. That's the success the defense wants, and it's right now the ball is in the prosecution's court. The death penalty is on the table, and it will remain on the table unless the prosecution decides to offer a plea with a lesser sentence, or the judge sanctions the prosecution and takes the death penalty off the table. Those are the only 2 ways it's going away. And if it doesn't go away, it doesn't matter how badly Mr. Robinson wants to plead, to take a plea deal. There is no deal. Deals are offered to the defendant, not generated from the defendant to the state. Let's see what. Let's see. Judge, is this double or triple spaced? Single space, 10-point font, narrow margin. Most murder trials are 3 years out. This is moving fast because it is a speedy trial, just like Koberger's was up until when he pled guilty. What is the thing that the defense is writing? The technical name, I can't remember. The submission? The state is actually going first because they are the requesting party, or they're the moving party in this preliminary hearing. The state is moving. They have filed a motion for the judge to bind over Mr. Robinson, and they've presented evidence. Defense has countered, and they have closed with rebuttal if they wanted to. They didn't, and now they're going to do the same pattern, state, defense, and state again, on the submissions for the bind over. What was the question? I'm looking for the question. Missed it. The real question is how long the trial will last. On the very narrow end, I can see 6 weeks. On the upper end, I could see 12. I don't see the prosecution offering a plea because they have all the evidence they have, and there's really no incentive for them to do so with all the evidence they have. Sometimes, if the victims in the family are specifically requesting that there's a plea to avoid court, to avoid the pain of going through this and reliving this over and over, prosecution will offer a plea deal. In this case, I haven't heard the victims ask for that. They basically said that's in the courts. We're not asking for the death penalty, and we're not asking for a plea deal. This is in the court's field, and the court has said, or the state has said, we'd like the death penalty. Next year at the earliest. I think next year for sure. I can't see this going to 2028 still be within speedy trial. Val says, I've loved watching you for a long time. However, your inability to remain objective, and this is frankly disappointing. No evidence aside from Lance to establish guilt. Why didn't they call parents? Val, I'm sorry you missed much of this trial. I apologize. We have DNA evidence. We have video evidence. We have confession evidence in multiple forms, some in handwritten notes, some in text messages, and some in Discord messages, all admissions of guilt. The stuff that didn't come in that we already know about is that he told his parents he did it. They said that. He turned himself in to police when they said, we're looking for this person of interest, and he turned himself in, I'm the person you're looking for. There's a lot of evidence, probably more so than we've seen in any case as to guilt. I don't know where you want me to be more objective than that. I think the state has proved their case definitely to the standard for the preliminary hearing, where they only need probable cause, which is very low, very, very low. Why didn't they call him? They don't need to present all the evidence. They haven't. They only need to present enough to show that they have probable cause to proceed here. There will be much more evidence and in more detail presented at the trial. 100%. For the record, I don't think you've been anything other than objective. Thanks, Frankie's World. I realize that he has not been tried. He has not had an opportunity to sit in front of a jury of his peers and have his day in court. That has not happened yet. That day is still coming, or should, if he chooses to go through this way. And when that happens, he will sit in court with a presumption of innocence, and we will all have to, as if we want to take the perspective of the jurors, view him in that moment as innocent and have the state prove to us in trial through evidence admitted to court that he's guilty. Now, the jury is not allowed to deliberate or think about everything during the case, and we don't have that restriction. We can look at evidence and weigh it as we go along. We can say, this person seems credible. That one does not. Lance, to me, seemed credible. And as we hear evidence, we can form our opinion. That's what we did this time as well. The state's not showing all the cards here. They're not, and neither is defense, I think. I think defense may have some sort of theory that they present. They might have hinted at some things, but I don't think they've shown everything. There's probably more evidence, a lot more. We know that there's more to letters, like that letter that we got the media sanctioned over. We only saw part of that letter. There is more to that letter that we haven't seen. Stuff about, I hope there's part of a sentence that was shown. I hope we got a chance to live, we don't know where that goes, but there's more. Might not be relevant, might not come into court. Can't wait to see internet searches. Let's see. Melissa says, there are plenty of holes. I did not find Lance credible in the fact that Tyler had never talked about Charlie Kirk before that day he unalived him. I don't think you need to talk to someone before you commit a crime, especially if that person is not interested in the same thing that you're interested in. Like there are people I know and talk to on a regular basis that I never discuss cables with, or very seldom discuss cables with, because they're not interested in cables like I am, and I love them, and I know a lot about them, and I make decisions in life, big decisions based on when I'm getting more cables, but even if them being in a relationship, I don't see it. Maybe you're saying that you think Lance knows more than he did. Or do you think that, I think they might try to imply that Mr. Twig was the shooter and that Tyler Robinson was trying to take the fall for him. I think this is an easy, very, very easy thing to clear up. We have Lance's phone and we have Tyler Robinson's phone. And we're going to do extractions on them with cell pings. We'll have timestamps of when they were typing, when they unlocked it, using their face, or when they entered their code, where it was, who was in possession of it, and it will put them at different areas at different times. And for me, that's settled at that point. Yeah, there's a possibility that Lance paid somebody to be his body double and act as him in texting on his phone. That's not reasonable. Possible, but not reasonable. And I think that evidence will come out in court. I think if for any reason there was doubt about that, we would have seen that doubt in court with the defense. They would have raised that right here. But I think the defense knows that that's not a reasonable doubt, and so they didn't pursue it. Plus, Lance, being the shooter, he's got like hair down to his knees. And not the close cropped thing that Tyler has. And we've got all this video. We don't have flowing locks in the breeze in all this video. It just doesn't make sense. And, the idea that he could tuck it up underneath a tight baseball cap, I can't see it. Maybe prosecution did not show all of Lance's interviews. They didn't show the entirety of the interviews. There were portions that were not shown. Some of it might not be relevant in trial either, but parts of it the judge saw and considered that will be. I just can't imagine what other defense they could come up with for reasonable doubt. Radagast, the defense doesn't have to come up with anything. They can just say, we're holding the state to their burden. Prove it. And then when it turns over to defense, they can say, no witnesses, the defense rests. They don't have to do a thing, but they can still make the state have to prove it and then fight all the evidence as much as they can, as trial proceeds. All right. A lot of people think Twig's not being honest. I think the devices will help his testimony. I think the digital footprint that's left behind from his use of devices is going to authenticate and vouch for his comments and location and the truthfulness of his actions. Whether or not he knew more than he's letting on, that might be in there as well. And if so, I would expect, and the state has reserved the right to do, because even under the immunity deal, I would expect the state to pursue charges if they can prove that he knew what was happening or helped in the planning, or maybe they spitballed ideas about how this could work and how this could be carried out. I think they would pursue it in a heartbeat. Jen Jock says, my hair is long, but I can still get it under a baseball cap. Let's see who's on the phone here. Hang on 1 second. Sorry, I missed your name. One more time. Who's on the phone?
It's Meg Osborne.
Meg, how are you doing? I appreciate you drawing attention to the fact that my headphones are falling apart and the fake pleather earphone was flapping against my face. I ripped that part off now. Is that better?
So you did see it?
Yeah, initially I couldn't.
I got that.
But thank you. I will order a new pair.
So anyways, the real reason I'm calling is that we need to realize with, that last comment about them being upset that you're not in the middle. We're just like a group of friends hanging out, talking about what we think, So they shouldn't expect you to remain neutral because we're just all friends. Yes, you run the group, but you're one of us, man. You're supposed to have your opinion, your output, your feelings. And I think you definitely always defend the defense. You're very good about that.
Let me play devil's advocate and argue their point. I present myself to the courts as media, and I think the media should be unbiased. So I can see the argument of, you shouldn't have an opinion here. He hasn't been found guilty. But this is, it's different for me because we are seeing evidence, and we're at the end of that. We're at the end of the evidence. The state and the defense have both had a chance to prove to the judge why they think he is guilty or why they think he's not. I think the state did a fantastic job of proving that. I think they proved it beyond the probable cause theory. I think they met beyond reasonable doubt theory with just the evidence they've shown us so far. And that's why
and that's what we're doing. At the end of it, we're like, this is what we think.
Yeah. But he will 100%. He has the right to a jury that is unbiased, that will listen to this and judge his case based on the evidence that's admitted in court during trial, and I'll champion that. And we as witnesses, we'll have to have the goldfish memory and just forget about what we think we've heard, forget about what we've watched here, and go back and say, okay, state, prove it, because right now he's not guilty, and when the trial starts, that has to happen again, and I'll champion that all the way through.
Right. Well, thanks for fixing your earphones, and I'm surprised I'm the only one that noticed it, but it was a great 5 days.
I buy these cheap. Let me see. I found another pair. I have 2 more pair of these just within arm's reach. So I think one of these is new, but they're the cover for the earpieces, it just slides on using fake pleather, and that little shiny surface was peeling off. So
but it was just so cute. It was like your little buddy flapping in the wind, hanging out with you. I enjoyed him.
Unaware, I had no idea. But I will buy another pair because I
good on you, mate.
Can't
Looks
have that bugging you the whole time. Look who's in chat. Dr. G explains. Dr. G.
All right. Well.
Okay.
Go tear up the chat, guys, and thanks for a great week.
Yes, thank you very much, Meg. Appreciate it.
All right, bye.
Bye. Dr. G explains, a great friend of the channel and a fellow YouTuber, body language expert. But even attorneys in the media provide opinions on how strong a case is. Saying you think the state has a strong case is definitely not biased. I think I did okay on this one, Dr. G. We need to do something together. If you're still up for hanging out with the small folks, the wee folk, I'd love to look at possibly some of this. So Dr. G has made it big time because he's really good at what he does. And you can find his channel, Dr. G Explains, here on YouTube. If you're not subscribed to that, do for sure. All right, I think I have your number somewhere. I'll make sure we reach out and do something. But thank you very much. We'll have to check in and see how you and the family are doing as well. Let's see. You can replace the cover. No, these are cheap headphones. I don't think you can replace them. I think I need a new one. Plus, I run over the cord with my roller chair and I ruin them. So one earphone goes out, and that's terrible. Let's see. Anything else we need to address with as far as this hearing goes? We've run like a 6-week sabbatical, although we will be able possibly to read some of the documents as they're filed. So when the state files in 2 weeks, we could read that. 35 pages. That's a long read, but we can do that. And we can also sort of keep any updates as things happen that way. I think, honestly, if the judge requires, and he's sort of reserved judgment about the September 1st date, but if the judge requires a delay in the broadcast, that goes from we'll send a cameraman with a live view to let's send a live truck. Expense-wise, it skyrockets. That is not, it's not cheap and easy to do. There's some ways you can like work around it with using like a private feed, and then you rebroadcast it, using the YouTube delay and everything. So, but the actual applying that filter, if he says, okay, stop, don't let that go out, that gets so convoluted that, I'm not sure who's going to sign up and want to be the pool media for that. Let's see. Wow, you would convict on this evidence. What's wrong with you? I'd wait to weigh the evidence. And Nili Badili, welcome. Thanks for joining us on the last day. We have had 5 days of evidence, and not sure if you got to watch it all. Part of it were confessions that I believe, and they hold a lot of weight with me. So yes, I would have convicted on this evidence had this been the trial. Trolls in abundance. Yes, they're out there. The problem is a lot of the investigation was done by Reddit, and by people who were searching for clicks by putting outlandish things out there on the internet. Because this operated in a vacuum a little bit, because media was excluded in part at the beginning, it allowed the mushrooms to grow. And there's a lot of that. I think the transparency will put that to bed. I think that'll put that to rest. The voices, the shrill voices that are screaming alien abduction, will become less and less relevant as that goes on. And that's why we like the transparency that we get. I think we're definitely going to go to trial, though, for sure. Okay, we are going to go to lunch. Thank you all. Nicole, I see that. It's 2:30 right now. I don't know if we can start one today, but possibly Monday. Does that work? Is Mrs. R.A. here? Scott, you did amazing doing whatever. Hey, thanks, my biggest fan. And I hers. Thank you very much. I want to get in touch with Dr. G and see if we can possibly do something together, possibly on this trial, as we talk about some of what we've been able to watch. Nicole, I see that we could catch up and CK was adopted by aliens. Gidge, thank you very much. Media funds, thanks. I'm going to put that to the Utah exchange system, because we might need to buy a few more documents from this hearing before it's over. So thank you. All right, let's go to lunch, you guys. Thank you very much for being here. It's been a lot of fun. I have to give a huge shout out to my mods who have been absolutely amazing in handling this. We have a lot of new people, a lot of people who don't understand how we watch court and how we treat each other as we watch court. But I appreciate you guys being here. Hopefully you learned and liked it. If you did, come back and do it again. We'd love to watch court with you today. I think we're going to start fresh on Monday. This has been a very difficult week for our moderators who have been dealing with some big family events with two kids, two babies being born for our mods, one a nephew and one a daughter, and just amazing. So thank you very much for the mods. I think they deserve some time off on a Friday where they can go and do something without the stress of what's happening here in chat. So with that said, I do anticipate that on Monday we will have our like counter fully automated, and so that you can like the stream and instantly see your like represented in the numbers on chat, or I think that's, there we go, like that. Does that work? Now it's not working at all. Hopefully it'll be all fixed. Maybe as early as this afternoon. There we go. Now it's working. I think it's because I was on Wi-Fi. But thank you very much for all the likes. I appreciate that. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again. We'll be live Monday. And yes, Nicole, that might be where we're going. We'll have a good case. And we've got some stuff out of Tennessee to do too. You guys, thank you very much. We'll see y'all later. Bye-bye.